rise to repugnancy. Our today's session are dedicated for ways of strengthening state legal system and fostering a harmonious working between the Union and its states. I am confident that participants in the conference will put forth useful suggestions on the agenda points as they did in the previous day. In case if any one of you has any query or clarification, please put forth your questions so that the same can be addressed right now in case of any confusion or any clarification. I came to know that Honorable Minister of Tamil Nadu is present. The Tamil Nadu Minister will be accommodated to hall number 2. Thank you. So if there is no further questions, may I ask the delegates to kindly move to your respective conference halls. States could repeat that. Hello, there's one more important announcement that we will be back. We will reassemble again in this hall for validatory session at 12:30 p.m. Sir, conference hall number. पूछना था ना सर अभी हाँ जी UT is in conference room number 1 itself. UT is here. Sir, conference hall number 2 में चलिए. No sir, 3. Chhattisgarh is in 3. Tripura. Tripura 1 itself. Yes. Uttarakhand. Yes, in Uttarakhand here. 1. Yeah. All UTs here. All UTs से खाली पुडुचेरी जाएगा उधर because of the ministry and rest will be here with us. I will repeat the names of the states and UTs who will present in conference room number 1. Punjab, Rajasthan, Sikkim, Telangana, Tripura, Uttarakhand, West Bengal, Chandigarh, Delhi, Daman Diu, Dadra and Nagar Haveli, Lakshadweep, Andaman, Ladakh, J&K. So in case if there is any delegate who belongs to some other state, may kindly proceed to their respective conference rooms. Hello.
Good morning, everybody. I think it will be better if we can all sit together and at least we can have some fruitful discussion, or do you think this is okay? The mic is functional, so it can be used, but then it's seeming kind of strange. Everybody is very far.
Pandey ji, it would be better in case if you move ahead, the first row.
Yeah,
So
that is what I was suggesting.
yeah, please come.
I think this is an interactive session basically for the benefit of the representatives of the states. If in case you have any query or in case you have any question which you want to ask or any suggestion you want to give, in case anybody wants to make a presentation also, they can. But the primary intention is to basically have a free and frank discussion so that any issues can be sorted out. I think we can start from one end. Bagra sir, we can start with you. No, sorry. Up to you.
Pandey ji, I think we have to start the presentations alphabetically, or in case if there is any issue with regard to any delegate moving early.
नमस्कार,
so he can make the presentation first.
नमस्कार मैडम,
Sir.
मैं प्रवीर भटनागर, राजस्थान से प्रिंसिपल सेक्रेटरी लॉ एंड लीगल अफेयर्स कम पीएडी। कल बहुत अच्छा चर्चा का विषय रहा और मीडिएशन से रिलेटेड जो अमेंडमेंट्स आ रहे हैं उन पे चर्चा हुई विस्तार से। उसी विषय पर कुछ मेरे सुझाव थे जिससे मैं अवगत कराना चाहता हूं। मैं
Sir, may I interrupt?
Yeah.
You are making the presentation now?
No, I am not making the presentation.
Okay.
I am just suggesting some views.
Okay.
So mediation से related मेरे कुछ suggestions हैं जिनको मैं आपके सामने रखना चाहूँगा। हमारे राजस्थान के एग्जाम्पल को मैं सबसे पहले कोट करूँगा। राजस्थान में 36 टोटल डिस्ट्रिक्ट्स हैं, जिसको हम कह सकते हैं डिस्ट्रिक्ट्स तो कम है बट जुडिशल डिस्ट्रिक्ट्स आप मान लीजिए, क्योंकि जयपुर मेट्रो 3 पार्ट्स में इटसेल्फ बटा हुआ है एंड जोधपुर, तो इट इज़ ओवरऑल 36। उसके बाद तालुका सिस्टम है डिस्ट्रिक्ट हेडक्वार्टर्स के अलावा, और टोटल हमारे पास ट्रेंड मीडिएटर्स जो हैं वो 1036 हैं। हमारे जुडिशल ऑफिसर्स का कैडर करीबन 1500 का है जो कि सारे केसेस को देखता है। मीडिएशन एक तरह से टूल की तरह कोर्ट में एडजॉर्नमेंट के लिए इस्तेमाल हो रहा है, ये कहने में मुझे कोई दो राय नहीं है, बिकॉज जब भी कभी कोई लोक अदालत लगती है तो अधिवक्तागण मीडिएशन को टूल बनाकर कि सर मीडिएशन में भेज दीजिए और वो डिस्पोजल हो जाएगा, जबकि डिस्पोजल नहीं होता है। मीडिएशन के अंदर कोई एफर्ट्स एज सच नहीं रखे जाते। जो जुडिशल ऑफिसर्स को मीडिएटर्स बनाया गया है वो मीडिएटर्स अपना जुडिशल वर्क करें कि मीडिएशन का करें, ये एक कन्फ्लिक्ट रहता है और उस कन्फ्लिक्ट का शिकार जो है फिर पार्टीज होती हैं, डेट्स होती हैं, एडजॉर्नमेंट्स होता है। तो जब ये सारी मीडिएशन के सारे लॉज हम इसको देख रहे हैं कि एक प्री मीडिएशन स्टेज होनी चाहिए लिटिगेशन को कर्टेल करने के लिए या उसको पहले से ही रिजॉल्व करने के लिए एडीआर प्रोसेस जो हम अपनाना चाह रहे हैं, तो मेरा एक तो सुझाव ये है कि जिस तरह से कॉमर्शियल कोर्ट एक्ट के अंतर्गत 12A का इंसर्शन हुआ और प्री मीडिएशन मस्ट कर दिया गया, तो सभी सिविल केसेस में प्री मीडिएशन मस्ट होना चाहिए। सेक्शन 89 का परव्यू बहुत ही इतना लाइटली कोर्ट में आने के बाद अगर मुकदमा आ जाए तो उसको यूज़ नहीं किया जाना चाहिए। बहुत ही कैलस मैनर के अंदर अगर सेक्शन 89 के अंदर हम रेफर करते हैं मीडिएशन में, और हमको मालूम है पहले मीडिएशन फेल हो चुका है, उसके लिए पूरे साल जाया हो चुके हैं, और पार्टीज बाय हुक एंड क्रुक, चाहे एक पार्टी मान लीजिए चाहे दोनों पार्टीज मान लीजिए, दे वांट टू टेक एडजॉर्नमेंट, तो इसको हमें कर्व करने की आवश्यकता है। तो मेरा ये सुझाव है कि हमें एक मीडिएशन सर्विसेज को क्रिएट करना चाहिए जिसमें हमारे पास अच्छे आर्बिट्रेटर्स हों, अच्छे मीडिएटर्स हों, और एक सर्विस का जब हम रूप देंगे तो निश्चित तौर पर कंडक्ट रूल्स अपने आप में एप्लीकेबल हो जाएंगे। हर लेवल के ऊपर मीडिएटर होना चाहिए, ये नहीं केवल डिस्ट्रिक्ट के ऊपर हो। आज तालुका जो है राजस्थान के अंदर, तो जो आप अगर वहाँ का क्षेत्रफल देखेंगे तो जैसलमेर जैसा डिस्ट्रिक्ट है, उसकी परिधि जो है करीबन 200 से 300 किलोमीटर जाती है। कोर्ट्स जो हैं 100 से 150 किलोमीटर की दूरी पर हैं तालुका के डिस्ट्रिक्ट हेडक्वार्टर से। मीडिएशन के लिए कोई भी अपने तालुका को छोड़कर मीडिएटर के पास डिस्ट्रिक्ट्स में नहीं आएगा, क्योंकि तालुका पे सारी सर्विसेज नहीं हैं। तो पहली बात तो हमें इंफ्रास्ट्रक्चर जो है तालुका से रिलेटेड और डिस्ट्रिक्ट से रिलेटेड बहुत ही स्ट्रेंथन करना पड़ेगा। उसको स्ट्रेंथन करने की बहुत आवश्यकता है। विदाउट उसको स्ट्रेंथन किए हम मीडिएशन रूल्स ला देंगे, मीडिएशन एक्ट ला देंगे, हम अपना जो हमारा एम है उसमें इतने सक्सेसफुल नहीं होंगे। तो हमें स्ट्रेंथन करने की ज़रूरत है। हमने बहुत सारे प्रैक्टिकल करके देख लिए, और ये प्रैक्टिकल हमने एडीआर के सिस्टम के रूप में एक सिस्टम को इंसर्ट कर दिया जुडिशियल सिस्टम के साथ। वो एक स्ट्यू बन जाता है, जैसे खिचड़ी सिस्टम हो जाता है, वो हो गया, और एक तरह से काफ़ी कुछ मैनेज होने लग गया कि केवल लोक अदालत के पर्पस से फिगर्स को मैनेज कर दिया जाए। सेटलमेंट के प्रोविजंस ऑलरेडी सीपीसी में है, 320 सीआरपीसी में अबेटमेंट के प्रोसीजर दे रखा है कि कॉम्प्रोमाइज़ करके कार्यवाही अबेट हो जाएगी। तो इतने सारे लॉ होने के बाद ये मल्टीप्लिसिटी ऑफ प्रोविजंस उन्हीं उसमें डाल देना। 87 से चल रहा है ये लीगल सर्विसेज अथॉरिटी एक्ट, लोक अदालत शुरू हो गई थी 86-87 से ही। उसके बाद से हम फिगर्स देते आए हैं, लेकिन सब्सटेंटिवली हम कितना जस्टिस कर सके हैं इस पे हमें देखने की आवश्यकता है। और जब तक हमारे पास डेडिकेटेड सिस्टम नहीं होगा तब तक हम कितने भी प्रैक्टिकल प्रयोग करते रहें, वो प्रयोग सक्सेसफुल होने की संभावनाएं बहुत कम रहती हैं। नो डाउट कि हम मीडिएशन के थ्रू अभी भी कई जगह बड़ा अच्छा मीडिएशन का, जैसे दिल्ली में कहते हैं, दिल्ली इज एग्जाम्पल कि वहाँ मीडिएशंस बहुत सक्सेसफुल हैं, बॉम्बे में हैं, लेकिन अभी और स्टेट्स के अंदर मीडिएशन केवल एक फिगर के रूप में है, और सब्सटेंटिवली उसका जो प्रोजेक्शन या रिफ्लेक्शन आना चाहिए वो एक ट्रू पिक्चर नहीं है। मेरा कहना यह है कि वो ट्रू पिक्चर नहीं है। तो हमें ज़रूरत है एक डेडिकेटेड सर्विसेज की, और ये प्रोविजंस इंसर्ट होने ज़रूरी हैं मीडिएशन के, और जब तक वो इंसर्ट नहीं होंगे तब तक मुझे लगता है कि हमारा जो एम है कि जस्टिस एट डोर स्टेप्स और एक त्वरित गति से न्याय का, उस एम को हम अचीव नहीं कर पाएंगे। बरसों बरसों मुकदमे चलते हैं, रोज़ की आज की नहीं 50 साल से यही बात हो रही है, और उसके बाद भी हम वहीं खड़े हैं। हमने बहुत प्रयोग कर लिए। तो मेरा यह सुझाव है कि मीडिएशन के लिए इंस्टेड ऑफ एडवोकेट्स आप क्वालिफिकेशन रखिए, एक डेडिकेटेड सर्विसेज बनाइए जिससे कि हर जगह मीडिएटर्स की अवेलेबिलिटी रहे, एक उनका पूरा सर्किल बने, उनके प्रमोशनल एवेन्यूज़ भी उसमें इनकॉर्पोरेट हों, तो वो ज़्यादा फ्रूटफुल रहेगा बनस्पत इसके कि हम फॉर द टाइम बीइंग एक हमने ट्रेनिंग पे खर्च किया 3 साल 4 साल, और वो मीडिएटर फिर चाहते हैं कि मैं मीडिएशन ना करूं या उनके कोई इंटरेस्ट डेवलप हो जाए। बेटर ये है कि एक ट्रांसफरेबल सर्विसेज हों, अलग अलग जगह जाएं, मीडिएटर्स अपॉइंट हों, ट्रेंड मीडिएशन, आजकल फिर लॉ कॉलेजेस में भी आर्बिट्रेशन और मीडिएशन के चैप्टर्स को बार काउंसिल को और मिनिस्ट्री ऑफ जस्टिस को उसमें इंक्लूड करना चाहिए। हर जगह ये स्पेशल कोर्सेज होने चाहिए। LLM कम से कम आर्बिट्रेशन और मीडिएशन में हो, उन लोगों को तरजीह दी जाए। इस तरह की क्वालिफिकेशंस अगर हम ऐड करेंगे और फिर हम अपना ये प्रयास करेंगे तो वो प्रयास ज़्यादा सार्थक होगा और एक हम अपना जो एम है उसको अचीव करने में सक्सेसफुल हो पाएंगे। यही मेरा एक सुझाव है। थैंक यू वेरी मच।
धन्यवाद भटनागर जी। इन करेक्ट्स अगर हम आपकी बात को समझें तो वो ये है कि सस्ता, सुगम और सुलभ न्याय हो। मीडिएटर की आप एक अलग से सर्विस स्टार्ट करने का प्रपोजल दे रहे हैं तथा उसमें ट्रेंड मीडिएटर्स की बात कहना चाहते हैं।
Verma sir, I am interrupting you in between. I request all the delegates to kindly submit their pen drives so that we can make appropriate arrangements.
Madam, I am the law.
Sir, वो pen drive का दे दें वो. आप please carry on, sir.
Madam, I am the law secretary of West Bengal. We have to leave at 12:30 because our flight is.
Sir, अपनी pen drive का presentation दे दीजिए.
I have already handed over the presentation.
Where?
To my liaison officer.
Whatever may be your suggestions, so kindly give it in writing also. We have noted your suggestions. Your suggestions are very valuable. So appropriate persons will be looked into. So kindly.
West Bengal delegate, kindly give us your pen drive.
I'm Veena Kotawale, Joint Secretary from Legislative Department. I would like to, as and when the states make their presentation, whatever issues we have with that state, I would like to share. With respect to Rajasthan, there is, we are waiting for a reply with respect to unstart question number 3922 relating to section 80 of Civil Procedure Code, where we are yet to receive the inputs from the state of Rajasthan. And then one more, we had introduced, there was a proposal in 2013 for setting up a legislative council. And we have introduced a bill for, establishing a legislative council in that state. But subsequently, due to change of government there, it is still pending in the House, and we have been requesting for either give their consent to pursue or to withdraw. So that is also pending. These two issues are there with Rajasthan. I request that with respect to both.
Yes, yes, madam. मैडम, इसमें सेक्शन 82 वाला तो मुझे जाके फाइंड आउट करना पड़ेगा कि वो कहाँ इशू अटका हुआ है। जहाँ तक आपने कहा कि क्वेश्चन है और उससे रिलेटेड, तो डेफिनेटली उसको हम जल्दी से जाके कर देंगे। एज फार एज लेजिस्लेटिव काउंसिल को क्रिएट करने का प्रपोजल था, वो मेरे यहाँ से लेटर आपको रिप्लाई में भेजा हुआ है। दैट मैटर इज स्टिल पेंडिंग कंसिडरेशन बिफोर द कॉम्पिटेंट गवर्नमेंट, और गवर्नमेंट इस पर पुनः विचार करेगी। और हो सकता है कि वो, अब मैं उसके बारे में कुछ नहीं कह सकता बिकॉज दिस इज देयर पॉलिसी डिसीजन। 2013 में लिया था, दे में चेंज इट और दे में नॉट चेंज इट, दे में अगेन परस्यू इट। सो बट हमने उनके सामने मैटर रख दिया है, चीफ मिनिस्टर के सामने, एंड उन्होंने स्पीकर के सामने उसको चर्चा के लिए रख दिया है। एंड वेरी सून हम उसके ऊपर जो भी डिसीजन होगा उसको कोशिश करेंगे कि उसको जल्दी से कर दें, क्योंकि गवर्नमेंट के उस पे है तो हम केवल एक परसुएंस थोड़ी बहुत कर सकते हैं।
But because it's pending since 2013.
Yeah,
so
I know that,
only,
madam.
It can be expected.
और 2021 में हमने लास्ट में आपको लेटर भी भेज दिया है, एंड दैट लेटर मैंने व्हाट्सएप किया था। अगर आपको नहीं मिला है तो आई कैन स्टिल गिव यू ए कॉपी ऑफ दैट लेटर।
No, if it is there in the section, it will be there available.
Okay.
We will consider.
Okay.
But only my request is in respect of both, please expect it.
Yeah.
Thank you so much.
राजस्थान के विषय में फास्ट ट्रैक स्पेशल कोर्ट के बारे में विशेषकर जो कल भी बताया गया था कि पीएफएमएस का कंप्लायंस नहीं हुआ है, और इन द मीन टाइम पीछे हम लोगों को जो एंट्रीज मिली थी, जो विवरण मिला था, उसके अनुरूप उन्हें फर्स्ट इंस्टॉलमेंट के लिए प्रोसेस कर दिया गया है, सैंक्शन ऑर्डर हो गया है, पर चूंकि एंट्रीज तालमेल नहीं कर रही हैं, कंप्लायंस नहीं हो रहा है, इसलिए वो मामला लंबित है। तो मेरा अनुरोध ये है कि वो कंप्लायंस से सारी एंट्री, सुना था कि शायद किसी दूसरे स्कीम की एंट्री इसमें एफटीएससी में हो गया है, तो संपूर्णतः उस कंप्लायंस को देखने की जरूरत है, जिससे कि त्वरित गति से हम वो फंड रिलीज कर सकें फास्ट ट्रैक स्पेशल कोर्ट पोक्सो के बारे में।
सर माय नेम इज अंकित रमन, आई एम जॉइंट सेक्रेटरी लॉ फ्रॉम राजस्थान। सर इसमें हम दिखवा रहे हैं SNA 1 और SNA 9 का जो प्रॉब्लम आ रहा है उसमें थोड़ा सा सही है सर। SNA 1 और 9 में थोड़ा सा डिफरेंस आ रहा है सर। जो 30 करोड़ 8 करोड़ अनस्पेंट में शो हो रहा है सर, इसको हम दिखवा रहे हैं सर। जो राजस्थान की PFMS टीम से हम कोऑर्डिनेट कर रहे हैं सर, और राघवेंद्र सर से भी बात हुआ है, वेडनेसडे को सर इसका मीटिंग रखेंगे सर। तो इसका जो भी आउटकम निकलेगा सर उससे हम आपको अपडेट करेंगे।
2 CSS स्कीम्स हैं, एक तो इंफ्रास्ट्रक्चर की है और ये फास्ट ट्रैक की स्पेशल कोर्ट्स वाली है, क्योंकि ये आप लोगों का हम लोगों ने सैंक्शन करके रखा हुआ सैंक्शन ऑर्डर।
एक प्रॉब्लम जो होम डिपार्टमेंट का आया है कि वो निर्भया फंड वाला पैसा उसमें शो होता है सर, उसका लॉ डिपार्टमेंट से कोई कंसर्न नहीं है, उसको भी हम क्लियर करेंगे सर।
मामला है एक्चुअली ये निर्भया फंड से ही वो दिया जाता है, तो कृपया जहां भी इसमें अवरोध आ रहा है उसको जल्दी से करें, क्योंकि राजस्थान तो फोर फ्रंट में ये कोर्ट चला रहा है और सारे डिटेल्स मिल रहे हैं
सर,
पर फंड्स भी जाने चाहिए समय पर।
एक रिक्वेस्ट और है सर कि ये जो PFMS से मैपिंग करा हुआ है IFMS का या और इसका, ये अभी इंस्टीट्यूशनलाइज हुआ है, इनिशिएट हुआ है सर। इस साल का एग्जाम्पशन दीजिए सर, क्योंकि ये अभी थोड़ा सा इसको चालू करने में थोड़ा समय लग रहा है और हम नई चीज़ों से इसमें इंट्रोड्यूस हो रहे हैं। तो प्लीज़ सर इस साल का एग्जाम्पशन करके इस बार का तो फंड रिलीज कीजिए, फिर अगली बार तो सर हम इसको देख ही रहे हैं।
देखिए, जहाँ तक रिलैक्स करने की बात है, पिछले साल भी इसी तरह से थोड़ा थोड़ा एग्जाम्पशन करके और पूरा वित्तीय वर्ष बीत गया। तो इस बार डिपार्टमेंट ऑफ एक्सपेंडिचर ने सीधा लेटर लिखा है कि ये सारे कंप्लायंसेज होने हैं। फिर भी कहीं कहीं बहुत बड़ा जो मुद्दा आ रहा है, जिससे सारे स्टेट्स की बात आती है, सैलरी इम्बर्समेंट के बारे में कुछ प्रॉब्लम आई थी जो सेंट्रल PFMS को रेफर किया गया, उन लोगों ने भी थोड़ा टाइम मांगा है, तो उस मामले में थोड़ा सा रिलैक्सेशन मिल रहा है। पर ये तो मान के चलें कि अब रिलैक्सेशन इसमें नहीं मिलने वाला है और ये कंप्लायंसेस करने ही पड़ेंगे फंड रिलीज के लिए।
एक छोटा सा प्रॉब्लम और आ रहा है कि सर राजस्थान में जो ट्रेजरी और स्टेट्स में शायद हो सकता है सर इस सिस्टम को अडॉप्ट कर रखा हो कि जहां स्टेट ट्रेजरीज को वेंडर बना के पैसा रिएम्बर्समेंट करते हैं। सर हमारे ऐसी कोई व्यवस्था भी है नहीं है सर।
उसी इशू को देखा जा रहा है और उसमें थोड़ा सा रिलैक्सेशन लेने की कोशिश की जा रही है। इसके अलावा अपनी पूरी तैयारी रखें और दूसरी एंट्रीज यदि इधर उधर हैं तो उसको रेडीनेस में रखें, जिससे कि आगे हम लोग कार्रवाई कर सकें।
Issue I have with Rajasthan is that out of 229 state laws which we had requested for repeal, 1980 and 1993 ka 5 acts of appropriation and vote on account act are pending for repeal. I wanted to know any
Yes.
action being taken.
यस मैडम इसमें एक कमेटी बनी हुई है हमारी हाई लेवल की, एंड उसने एक्सरसाइज पूरी कर ली है। अब हमें रिपील एक्ट पेश करना है और उसमें मेरे ख्याल से काफ़ी सारे एक्ट है, 60 तो हमने 2015 में रिपील किए थे। अब उसके बाद ये एक्सरसाइज टेकन अप करके अब अपने फाइनल स्टेज पे आ गई है। एंड जब भी सेशन होता है विधानसभा का, तो उस सेशन में हम कोशिश करेंगे रिपील एक्ट लाके उनको रिपील कर दें।
Okay, thank you.
सर गुड मॉर्निंग, मैं तेलंगाना नरसिंह राव आपके पीछे। सर मेरा एक क्वेश्चन है सर, हमारे यहाँ वी हैव स्टार्टेड अबाउट 11 मीडिएशन सेंटर्स है एंड देर आर अबाउट we have already trained the advocates and we are also master trainers and regarding that, and also we have judges who have been already trained. We have mediation center attached to the High Court Legal Service Authority में mediation center का ये है, वो डायरेक्टर भी है, इंचार्ज है। और यहाँ पे mediation center में ये बजट के बारे में आपसे कोई हमारे को इंफॉर्मेशन आता है या क्या सर? हाउ द बजट इज बीइंग शेयर्ड बाय द सेंट्रल गवर्नमेंट? इज एनी बजट इज गोइंग टू बी गिवन बाय द सेंट्रल गवर्नमेंट? वो एक बात है सर। और एक ये निर्भया फंड में जो है ना सर, इसमें विक्टिम कॉम्पेंसेशन के लिए कुछ बजट आप एलोकेट करते क्या, उसके बारे में?
जहाँ तक विक्टिम कंपेंसेशन के बजट के एलोकेशन निर्भया फंड जो कि फास्ट ट्रैक स्पेशल कोर्ट की स्कीम है, तो इस स्कीम में इसका प्रावधान नहीं है। स्कीम के अंतर्गत इस चीज को नहीं रखा गया है विक्टिम कंपेंसेशन, पर इसके अलावा विक्टिम कंपेंसेशन यदि दूसरे केसेज में आता होगा, उसमें होगा तो उसमें कवर्ड होगा, पर ये इस स्कीम के तहत नहीं है। निर्भया फंड से जो पैसा हम देते हैं फास्ट ट्रैक स्पेशल कोर्ट के लिए, तो उसमें जो मेन कंपोनेंट है वो है सैलरी, अदर एक्सपेंसेस और जो कंप्यूटर एक्सेट्रा, जो रेंटल बिल्डिंग्स, इफ कोर्ट बिल्डिंग्स आर नॉट अवेलेबल। तो ये 3 कंपोनेंट है स्पेशली। बेसिकली उसमें मोर देन 90% वो सैलरी कंपोनेंट है। जुडिशियल
इसका कुछ प्रोविजन कर सकते हैं सर?
के अंदर है ना।
हेलो,
हाँ, नालसा है।
NALSA is providing all the budget for that.
It is providing in the state also. State is also providing.
हाँ, state is providing.
ये मीडिएशन के बारे में सर, एनी बजट विल बी प्रोवाइडेड।
मीडिएशन से संबंधित जो भी आपकी सबमिशंस हैं उनको आप रिटन में दे दीजिएगा। वी विल लुक इनटू।
स्टार्ट किए हैं, मीडिएशन प्रोसेस भी चल रहा है। ओनली थिंग इज रिगार्डिंग द इंफ्रास्ट्रक्चर इन द मीडिएशन सेंटर्स एंड अदर,
देखिए
एक्सपेंडिचर,
जितने भी कोर्ट बिल्डिंग्स है या किसी से भी आपका बजटरी प्रोविजंस हैं, फाइनेंशियल एस्पेक्ट्स हैं, वो तो फाइनेंस डिपार्टमेंट देखेगा। या हमारे यहाँ पर कोर्ट के लिए, प्रेमिसेस के लिए अगर कुछ प्राविधान है तो उसके संबंध में जो भी संबंधित मंत्रालय या संबंधित विभाग होगा उसको आपका एप्लीकेशन फॉरवर्ड कर दिया जाएगा। तो काइंडली इसको आप रिटन में भेज दीजिएगा।
ठीक है।
मैं चाहूँगा कि वेस्ट बंगाल वाले शायद जल्दी आना चाहते हैं, वो अपना जो भी सबमिशन है रखें।
गुड मॉर्निंग सर, गुड मॉर्निंग मैडम।
मैडम,
With respect to
वेस्ट बंगाल उनका कोई फ्लाइट छूट रहा है।
नहीं, तेलंगाना it is not finished.
तेलंगाना को बाद में ले लेंगे।
Okay, ठीक है।
वेस्ट बंगाल प्लीज।
Okay. Let the presentation.
Yeah.
May I request the West Bengal delegate to kindly make their presentations?
Slide it. We have made a presentation for about 31 pages regarding theoretical part. I am skipping over, and I am only reading out the material parts. Regarding mediation for speedy justice, the function of the Judicial Department of Government of West Bengal is to provide mediation centers for each district, which should promote the concept of mediation for speedy justice. And 2 mediation centers have already been set up. Installation of video conference facility at Mediation Center, High Court, Calcutta, and for that reason administrative approval of rupees 5,22,523 has been made, and administrative approval has already been accorded and fund has been released. And another is construction of mediation center with repairing of approach road at Kalimpong District Court, and for that reason 8,89,733 has been approved. And the other things is that development of centers for excellence of law and justice. Initially, the Judicial Department of Government of West Bengal and now the Law Department Government of West Bengal is playing a vital role by holding the administrative control in the matters connected with the West Bengal National University of Juridical Science. Necessary provisions are made in the budget of Law Department for grants of for grants as required by the Said University, and supplementary grants are also allocated to the Said University from time to time as per requisition of the Said University. And regarding upgradation of judicial and upgradation of infrastructure of courts, central and state funding 60-40, infrastructure facilities for subordinate courts have been suitably improved a lot since 2016. The high-powered committee constituted under the aegis of Chief Secretary, Government of West Bengal, in compliance with the solemn direction of the Honorable Supreme Court in Malik Mazhar Sultan and others versus UP Public Service Commission and other, is regularly monitoring the development of various projects relating to infrastructure, development of subordinate judiciary in case-to-case basis, and also in regular interval. The Judicial Department has, on the basis of the recommendation of the Honorable High Court, undertaken a number of projects. ওটা ওইভাবে দিচ্ছে তো, ওটা তো রোল করতে হবে, তবে তো জায়গায় আসবে। আপনি রোল করান ওইভাবে। The Judicial Department has, on the basis of recommendation of the Honorable High Court Calcutta, undertaken a number of projects of the subordinate judiciary, like construction of courtrooms, including dedicated child-friendly proxo courts, residential accommodation of judges of the districts and subordinate courts, major maintenance works of Calcutta High Court, West Bengal Judicial Academy, circuit bench at Jalpaiguri, etc. Present status and completed and under construction projects. Court buildings completed, total 656. Court building under construction 92. The fund released in last 3 financial years for construction of court complexes. 2019-20 courtrooms. Regarding courtrooms, state fund is 19 crores 97 lakhs 78,010, and central fund 30 crores 21 lakhs 66,958. Total 50 crores 9 lakhs 44,968. 2021 courtrooms. Regarding courtrooms, state fund is 13 crores 9 lakhs 72,124, and central fund is 17 crores 54 lakhs 97,635. Total 30 crores 64 lakhs 69,759. 29-21 courtrooms. Regarding courtrooms, state fund is 9 crores 63 lakhs 37,356, and central fund is 8 crores 10 lakhs 38,753. Total 17 crores 73 lakhs 76,109. And progress on implementation of subordinate judiciary through construction of residential complexes. During the last 3 financial years, construction of residential complexes for judicial officers have been completed at Krishnanagar, Navadvip and Kollani at Nodia district, Khatra at Bankura district, Siliguri at Darjeeling district, Ranchi Road at Purulia district, Asansol at Paschim Bardhaman district. And present status of completed and under construction projects. Residential quarters completed 68, residential quarters under construction 32, and fund released in last 3 financial years for construction of residential complexes. In 2019-20, Total fund release is 18 crores 65 lakhs 23,725. 2021 state fund, the total is 10 crores 23 lakhs 67,669. 2021.
Excuse me for 1 minute. If you have any particular points to raise, please restrict yourself to that, because other people also have to speak. So this you can give a written submission, giving your achievements. They are welcome, but we don't need to read it out like that. So please keep it brief.
In brief, I can say that we are facing a great difficulty due to lack of proper accommodation from the Public Works Department, because we have already completed the projects of 21 crores and something, but regarding that, the proper utilization certificate has not been given by the Public Works Department. And for that reason, we are unable to show officially that the said fund has already been utilized. And regarding some other aspects also, there are commercial courts. We have already set up 4 commercial courts, and they are being run. And regarding mediation, my suggestion, there is no specific suggestion from my part, because regarding mediation, discussion has already been made, and we are facing the same troubles from the lawyers concerned, because lawyers are not assisting properly in respect of mediation, and for that reason we are unable to dispose of considerable amount, considerable number of cases through mediation. So regarding other things, I have no other suggestion, and if I am allowed to make my submission through a presentation, then I can proceed.
Any latest development regarding fast track special courts scheme, because we are yet to receive the consent, formal consent from the state of West Bengal. 123 courts are earmarked for that, and 2 years, more than 2 years have just passed. The scheme presently is up to 31st March of 2023, though it is being processed for extension, but we have not received the consent. It was told that it is being looked after by a committee. If any latest development is there, please let us know.
Regarding latest development, I am unable to say anything because the matter is pending with the Honorable High Court. I have written several letters to the Registrar General regarding the latest position, but till now nothing has been intimated to me. For that reason, I make anything to say today with regard to the latest position. Regarding exclusive POXO courts, have been the government of West Bengal has sanctioned regarding 7 POXO courts, e-POXO courts has already been sanctioned, and out of the 3 have already been set up.
But it is also pending for concurrence of the Honorable.
But the same are also pending for concurrence of the Honorable High Court. That is the latest position.
There are 15 acts of West Bengal which we requested for repeal. They are yet to be repealed. And then there are 7 Law Commission reports regarding which we have sought your inputs, and there is 1 parliamentary question, so I request you to expedite in respect of this. This parliament question is on religious trust in states. So please give your inputs and please take steps to repeal those 15 acts.
Several acts have already been repealed, and some are pending for the action of the respective departments. In my presentation, I have stated in detail about the action with regard to repealing and repealing obsolete laws.
Sir, I'm Secretary under Law on second chance may be given to us because
yes,
we are
please.
in a hurry to.
Please carry on.
Sir, we have not given any details presentation.
The West Bengal. So I would like to.
Actually, sir, I am also in a hurry because my flight is from Ahmedabad, so I have to leave early, sir. That's the reason, sir. That's why I'm requesting.
What is the time of your flight?
It's 7 to 25 from Ahmedabad.
Very ample time. Very ample time.
5 hours journey it is to take from here.
We also proceed in the same manner. We will also proceed.
Let him submit, sir. I have time.
No, Telangana, I have only same request I want to make.
Madam?
That there are certain acts regarding the Law Commission reports, inputs.
Only
There
Law
are
Commission
almost
report.
30.
I think except
Almost in all
only
the
Law
country.
Commission reports we have to, sir,
Yeah,
regarding
yeah,
that.
that inputs
There are
and-
no acts which are yet to be
No, no,
repealed
acts
from
are
our
not
side.
there. Law Commission
And regarding the
reports.
two questions, that is one is religious trust.
Yeah.
So I have an answer to that, but presently it's not with me. I'll submit it immediately after I go. There are no religious trusts have been, but I'll submit
please
after
submit.
sending it to my minister, and I will submit it. And regarding the other question, I have sent it to the High Court regarding Section 82. I think. I have sent it to High Court. I have to get the information from the other district courts and the High Court. After that, I'll place it with the minister and I'll send it to the.
And black magic and witchcraft.
That one only.
Okay, thank you so much.
But please carry on.
Yes, sir. Myself, Secretary Law Andaman. Sir, I have not given the detailed presentation in the traditional mode, but I've got with me the written things of that. So far as the mediation is concerned, sir, the one area center is already there. And we have the trained 5 mediators who are advocates basically. They have been trying level-based to get the mediation a grand success. We have been taking acting role in the same because I am also the member of the SLSA. So I am to take part in the said proceeding. So we are happy with the thing that the ADSR and the mediation committee is functioning over there. Next is we have to create a different separate building for the mediation center. That's we are lacking. It's an old building where the mediation center is now just having its function. So we are taking proactive step to get it done within a very short span of time, sir. So far as the agenda points are concerned of the Department of Justice, sir, the first agenda is upgradation of the infrastructure of the courts. With regard to that, the action taken plan I am going to deliver. Adequate judicial infrastructure provided to the district and subordinate courts by UT fund and administration, as well as the centrally sponsored scheme as and when required. So far as the exclusive residential accommodation for the judicial officers of Andaman and Nicobar Islands are concerned, it is pertinent to mention that only 5 judicial officers having their respective exclusive residential accommodation, whereas the other 6 judicial members don't have the same. At present, they are having accommodated by the UT government and administration. So the other 6 residential accommodation for the said officers are to be built up. Second point was the e-court and digital courts. Sir, it is I'm very happy to inform that district and all subordinate courts have e-court facilities and functioning digital courts in the UT administration in Nicobar Islands. So for the third point, that is access to justice, telelaw and legal literacy is concerned. We have already implemented the telelaw project in collaboration with the Department of Justice, and we have selected Mrs. Prija Menon as a retainer lawyer for the same. That has already been communicated by our earlier correspondence to the Department of Justice to that in this regard. With the directions of the NALSA, over 15 government schools have been identified and established for functioning of legal literacy club. Legal aid clinic has been set up in the district correctional home, Prothrapur, Port Blair, and a permanent lawyer has been appointed there to facilitate the legal awareness aid amongst the convicts, UTBs, and accused persons after having the approval of the Honorable Executive Chairman, Andaman and Nicobar State Legal Services Authority. With regard to fourth point, that is reduction of pendency of cases and ensuring speedy disposal, roadmap for future, we have to say that through special fast-track court, though the special fast-track court can reduce the pendency of cases and it may ensure the speedy disposal of cases, but the fact remains that no fast-track court of the nature has been set up here in this island. Because of the fact, the Andaman government is not responsible for that. It is I have already discussed the same with the Department of Justice, that Andaman and Nicobar Island comes within the jurisdiction of Calcutta High Court. And it has been the standing policy of the Calcutta High Court that every fast-track court must be manned by a serving judicial officer, not by a retired one. So we have already approached the Honorable High Court to provide us with a serving judicial officer so that our infrastructure is almost ready. We can do the same. As and when the same is provided by the Honorable Court, we are ready to move the same. Vacancies. So far as the fifth point is concerned, vacancies in the district and subordinate courts, all these sanctioned posts of judicial officers are filled in the district and subordinate courts. No vacancy exists at present. However, there is no special court like essential commodities court, labor court, commercial court, CBI court, and consumer court. Regarding the fast-track court, fast-track special court, I have already identified that there is no fast-track court of any nature, not even POXO court. So the same thing I am to repeat and reiterate with regard to my earlier submission. So far as the vision 2047 of the Law and Justice is concerned, we have already proposed, we have just made certain visions for the said project. First one, establishment of the separate POXO court in the district of South Andaman. Sir, Andaman is consisting of 3 districts, North Andaman, Northern Middle and South Andaman. So no fast-track court has been there functioning, but there are a number of POXO cases. And it's a fact, sir, I want to bring it to the notice of the authority, that these Andaman and Nicobar Islands is infested with the tribal communities, such as Nicobaris, Sompens, Jarwas, Sentinelese, within whom there has been a convention or standing convention, there has been free mixing between the boys and girls who are yet to come of the age. So by this thing, they often get pregnant. And whenever they go to a doctor, the doctor is duty bound to inform it to the local police station. But they want it, they don't want this community, they are putting their heavy resistance to this law. We are facing a lot of problems and challenges to regard to same, because we have to comply it statutorily. There has been statutory compliance. So we have been facing very problem with regard to proper implementation of the same. Because from every corner they have been resisting us that we don't want this law to be here. This is the main problem. Next, establishment of the separate Prevention of Corruption Act in the district of South Andaman district. Number 3, establishment of separate CBI court in the district of South Andaman. All these powers are now being additionally given to the district judges and other additional district judges who are already overburdened with their present system. So this is our vision, that in future we may create these special courts so that the burden can be lesser from the judiciary. Number 4, establishment of separate NDPS court, which is not there now. The establishment of separate commercial court in the South Andaman district. We have already come across that the stress has much been given upon the establishment of commercial court. But I'm sorry to say that no commercial court has yet been established over there, because there is no pendency of cases over there as much. One case is there, and more than less than 3 lakhs cases are already, power has been given to the Civil Judge Senior Division to go on settlement of the issue. Next vision is establishment of the separate POXO court in the district of North and Middle Andaman. establishment of separate Prevention of Corruption Act in the District of North and Middle Andaman, establishment of special essential commodities court in District of South Andaman. Next, establishment of separate CBI court in the District of North and Middle Andaman, establishment of POXO court in the District of Nicobar, installation of solar energy panel in the court building of all the district and subordinate courts in Andaman and Nicobar Islands. Next vision is establishment of the special essential commodities court in the District of North and Middle Andaman. Next, establishment of separate NDPS court in the North and Middle Andaman. Construction of separate court building for area center in South Andaman district, which I have just referred to before a while, that we don't have any permanent area center, and which is in a dilapidated, almost dilapidated building. So we want to shift it, and we want to get it renovated or establish a new one. Next, construction of permanent building at JMFC court at Diglipur. It's a very distant place, sir. It takes about 12 to 14 kilometers to reach Diglipur from Port Blair. And there are 3 creeks. It's a very remotest place of the island. So we have been trying our level best to construct a new JMFC court, where is this functioning? It is dilapidated only. It has already been declared condemned. We have already located the site map, place, everything has been settled. So we are going to do it for that. Next, construction of the separate child-friendly court at Nicobar district. We are going to do it in Nicobar, Mayabandar, within the course of 2 to 3 months. Already details estimated has been submitted. We are going to make it out. A piece of land is for construction of the court building and quarters of judicial officers and staff at Diglipur, North Andaman.
Excuse me, I think you will also need to restrict yourself if you have any particular suggestion.
That's why I'm just pointing to this. This is the last point, sir.
Yeah.
As far as the repealing of the provision, sir, you know it very well that Andaman and Nicobar Island, without any legislature, does not have any act. So we have some rules, regulations, notifications. We have already given the thorough list of the same to the concerned departments of Andaman and Nicobar Islands, and they have been pondering over the same as to which regulations or rules are not quite up to date or they have already been extinct. So they are taken care of. Unless the list will be provided, that will be taken care of. This is thank you also.
Thank you very much.
Good morning, everyone. I'm Nitin Kumar Yadav, Home Secretary as well as Secretary Legal in UT of Chandigarh. As you know, Chandigarh as being a union territory follows the laws of the central government. As far as the state laws are concerned, we just follow the Punjab state laws as has been adopted by order. Sir, so I have a presentation and in which we have elucidated all the major achievements of Chandigarh administration. So I would not be repeating those. So we have been working on a lot on the alternate dispute redressal mechanism, the mediation mechanisms, and for counseling of children, especially involved in various crimes and other matters. So those efforts, the feedback that we have, we'll be sharing with you in writing. Sir, I just wanted to, since this is a very high-level deliberation, and instead of just giving performances and those reports, I do want to touch upon a few points as far as implementation is concerned and the challenges that we face and what we can do collectively to improve the system. So, sir, if you see the broad mechanism, it is that we have a law. What we are working on is that how do we ensure a speedy disposal of whatever the law is saying. So we are trying to say, okay, have more courts, have more HR, have more. So you have a machine which runs efficiently to deliver that thing, which is fine. But then if you have a bad policy, if you have a bad act, no matter how good your machine is, it will not work. For example, bad affidavits, not a single case we have been able to have a prosecution in which we could say that, okay, someone has submitted a wrong affidavit and that you should prosecute him. And so government is forced now to have, leave the affidavit part, let's have just undertaking. or remove that thing at all, because you could not implement that law. So I think removal of obsolete law was the good first step, but it is an easy step because it is anyway obsolete. No one is using it. No one is bothered about it. When we made the list, it took us hardly 10 minutes to just see, oh, which was that law, that is, no one is asking about it. So just found a list and got a repeal done in the assembly. So that, since I come from Haryana cadre, I'm on deputation here, so I'm giving my experience in Haryana. But the second step would be, and the more important step, would be what laws are existing today and how are they relevant? Are they, when I say relevant, in terms of execution? The purpose that they were achieved for, they are working for, did they achieve or not? So we are looking at performance of courts. We are so bothered about performance of courts, of lawyers, of everyone. We are not looking at the performance of the act. There is no parameter in which we are even looking at the performance of various acts. So now we have policies like schemes, policies. Everyone says if the scheme is bad, if the policy is bad, then you can't implement it on the ground. Similarly, if the act is bad, it is not able to do. Now the problem is that who is pushing the agenda? It is the Commerce Department, it is the DIPP, which is telling us, see, you have a bad law, please decriminalize it, please do something about it, because it is stopping our investments. It is someone else who's pushing the law departments to reform. Now it is our job to push, at least first of all, make certain criteria in which we see how implementable the acts are and why they are not being implementable, and then ask the concerned departments to kind of take over and see how effectively we can run. And what Honorable Prime Minister mentioned yesterday about simplifying, it's not only language, it's about implementation. It's not only words, it's about the meaning of the act, which has to be also kept in mind. So without taking much time, what I can say is that because we have been implementers a lot in all practical sense, and I understand the challenge of law department, because every time legislative department, the law department, everyone comes, we think, oh, it's not our job, since it is a headache of the concerned department. The law is for them. If it is for food supplies, it is for land, revenue, it is their headache. They should see if it is implementable or not. If they have any problem, approach us, we'll see the language. And we should go beyond semantics. We should go beyond words and actually start the purpose of that act. A good step has been taken by the MHA by starting reviewing of Evidence Act and CRPC. Unfortunately, even that has come in a very simple manner, in the sense that if there's comments on these things, so people have not understood the impact that one is trying to make of it. So if when someone refers for suggestions to the states, I think if a broad background note is given as to why suggestions are being sought, it would help a lot in understanding the gravity, because most of the time states think, हम इतना दिमाग लगाएंगे, जाना तो होना तो कुछ है नहीं, तो हम क्यों दिमाग लगाएं? Always better that a core group is formed of states and centers, especially because many of these, even if it is a central act, many of the implementation lies with states. So it is always better that some core group is formed, some broad ideas are prepared, and then a confirmation kind of thing is sent to the states so that they know the background and why it is being sought out. Thank you very much.
That was good suggestion, but see, whenever you find any problem, if you have any feedbacks, if you have any, the field, because you're implementing, the states are implementing any issues in the field, you have to send the feedback to the concerned ministries department so that they can review their law from all the perspectives. So reviewing law is an ongoing process, and you're required to, if it is your state's matter, you'll be reviewing your own state acts. If you have any repugnancies or any issues with the central act, you have to bring it to their notice so that they can have. That's how, because a law cannot be stagnated, and it has to move with the modern times. So therefore, every state, they have to, in respect to those matters which have, affect them, they have to bring it to the notice of concerned ministries so that they can review their law. It is because the concerned ministry has to do it. You have to communicate to them about the issues involved.
I didn't want to take too much time, but I'll touch upon one point. So when Corona was there, under Disaster Management Act, there were orders which were passed. Now the nodal officer, we were the actual implementer. I was in the Chief Secretary office, handling every case, giving every directions. Now what happens is that under DM Act, the DM is, there is only one way you can take action. You had to impose lockdown, you had to do everything. And you will register case. You have to register case under the ND Act for any violation. Was it possible against 1 lakh people who were violating it? So the point is, now, did we have time, or any state had that mind to bother about implementation of lockdown or violation of ND Act? We were handling public health crisis. So we were more worried about the patients getting beds, increasing the capacity of hospitals and other things. So I am just trying to point out that there is always a nodal department which takes care of performances, right? So it is performance of the act. You have an act, are you using it? Has the department used it? So state government, even if it tells something, and I don't think it was possible for anyone to even say at that time that, okay, you have made or that act is not implementable. Who is the relevant authority? Who will register case? Will the DM register case against 1 lakh people for violating lockdowns? So I'm just giving an example. All that I'm saying is that, some mechanism needs to be done, and it's to be done by both. Thank you.
You want to say that act or law should be assessed.
Yes, absolutely.
Act should be or law should be assessed whether what are the main reasons that germines litigation.
Absolutely, absolutely. So when you say speedy disposal, it is not only
legal audit.
Yeah.
Is the concept behind it.
Yes.
So there may be a mechanism that we may evaluate the impact of laws, and whether it's germane litigations, whether there is any provision which is arbitrary in nature,
absolutely,
or maybe creating hardship to the persons, or it is not implementable.
Absolutely, absolutely.
So your suggestions is very good, and but with regard to initiation of process by the law department to amend the laws, we may assist the legal audit. We may impact. But allocation of business rules is there. There are the check and balances.
Agreed, sir. Agreed. So, sir,
one
even
department which is administering the act.
Yeah.
There are allocation of business rules. There are so many check and balances.
Absolutely.
So one department says that their purpose will be served only by this provision.
Absolutely. So I'm not saying that. Like a financial audit.
So a balancing approach is required.
Yes.
In consultation with all the stakeholders.
Yes.
Including the assessment of the impact of that.
Absolutely.
Okay.
Yes. So we have for example, in financial audit now they have introduced performance audit. So performance, it's like a performance audit.
Okay.
And that will help the departments to review it.
Okay. Next.
Just 1 minute, because we have time only till 12:30. So I'll request everybody to keep it brief, please.
Good morning, one and all. Myself, J.M. Panchal, Law Secretary, Dadra and Nagar Haveli, Daman and Diu. Since it's a small union territory, I will not take much time of all the participants, and will conclude within 5 minutes only. Before proceeding ahead, I'll just give an overview about this particular territory. That Dadra and Nagar Haveli and Daman and Diu is a union territory in Western India. It is comprises of 3 districts. Presently, there are 8 courts are functioning in this territory. And prior to that, as you all must be aware that these areas, 4 areas, were part of the Portuguese India and came under the Indian administration only in the mid of 20th century. In the year 2020, the merger has taken place, and now there is only one, all comprising of 4 districts, 3 districts. There is only one union territory. After merger, the first task which the UT administration has undertaken is to identify and make the recommendation for repealing the obsolete laws. We have sent the proposal around 107 acts which the UT administration find that has become obsolete. The process is right now still undergoing, because we have received recommendations from the MHA also to review, relook the some of the provisions which we have sought to repeal. So that process is right now undergoing. So far as mediation is concerned, as I said, that all the courts are functioning under the administrative control of Honorable High Court at Bombay. So we have trained judges mediators who do the mediation works, by devoting some their judicial time for this particular mediation task. Right now, after merger, we have also proposed to MHA, we are in the process of constitution of that one SLSA, because prior to that there were 3 districts. Now in view of merger, we have sent a proposal of constitution of one SLSA. Again, we are in the process of creation of post of the member secretary as well, and staff also. So far as mediation is concerned, as I have raised this issue yesterday also, that we need to bring uniformity in the procedure of mediation, because as I said, that judges do the mediation work, and at the conclusion of that mediation process, the judges are going to sign that particular agreement which is going to be executed between the parties. So the a question may arise afterwards if that agreement is challenged in the court of law, that whether the judge would be called in that particular proceedings, because he is not a judge in that mediation process, he is a mediator judge. So the question may arise in future also. Some judges don't even sign that mediation agreement. So what will be the legal sanctity to that particular agreement, which is...
Sorry to interrupt, sir.
Yes, sir.
All points which are raising you are today have already been raised.
Yes, sir. Just yes, conclude. Yes, sir.
What is the purpose of this repetition?
Yes. No, sir. Just a mediation point that I have it is there in my presentation. I want to highlight.
Sir,
okay, I'll skip.
Repeating the same thing.
Yes.
That may serve no purpose.
Yes. Second, sir, the promotion of alternative mechanism is concerned for resolving the disputes involving the government departments. We are in the process of identifying such kind of matters also, and the responsible officers from the respective departments to ascertain the aspects of resolving disputes in amicable manner by resorting to one of the mode of the ADR mechanism. So far as upgradation of infrastructure of courts, e-courts and digital courts are concerned, we have our own government buildings, court buildings, as well as government residential quarters also, and those are good enough as far as the number of judges functioning in the UT administration is concerned. Another one is reducing pendency. The Honorable High Court has periodically arranged the special drives to dispose of the stale and ineffective cases. Periodical reviews have also been conducted to identify and dispose of the summary cases by resorting to relevant provisions of law. As far as fast-track courts are concerned, considering the less number of cases, we haven't received any proposal from the Honorable High Court to constitute that fast-track courts. Sir, in respect of fast-track courts, with profound respect to the policy makers, I would like to make a suggestion. In fast-track courts, we do appoint the judges, retired judges, to deal with the matters which are having important that POCSO matters and the women-related matters. So, sir, we have an experience that the judges who are already retired and they work on the very less number of that salary, because they got the salary which was there in the last basic salary they receive, and the facilities which they were enjoying while serving in the judiciary, in mainstream judiciary, they don't receive after retirement also. So they they don't continue that particular post, and they resign also within a short span of 1 or 2 months. So we are not getting that much response to fast track courts as well. So instead of again with profound respect to the policy makers, instead of making engagement of the retired officers, can we give these particular appointments or the task of this dealing with these matters to the judicial officers who are there in 15 or 20 years of service, who are there in the service itself? It will help in 2 ways. they will also get some sort of motivation to do to dispose of the matters at an earlier way. And at the same time, the subordinate judicial officers also would get an opportunity to go ahead. Means the creation of post and creation of motivation amongst the judicial officers also will be taken care of. So it is my humble submission with respect to that particular fast track courts. Impact of commercial courts Act, again I am saying the same thing, that district judges and civil senior division judges are designated are the commercial courts and commercial appellate courts as per the their pecuniary jurisdiction which has been fixed by the government in consultation with the Honorable High Court. So the vision for the 2047 for law and justice is making courts paperless and litigant friendly, motivating advocates and litigants to opt for ADR mechanisms and decriminalizations. We have also undertaken that aspect also. We have called all the departments to identify the laws which are there and to decriminalize the provisions also. Thank you.
Thank you,
Thank you, sir.
1 minute, sir. Regarding fast track special court, the suggestion which you are making regarding engagement of retired judicial officers, this has often been made, but we have clarified also the scheme doesn't restrict that only retired judicial officers will be engaged. Only to give a boost if existing judicial officers are not available. So the state can go to engage retired judicial officers also. Also, it is not that is mandatory. So if it is there, if it is available, well, that should be. But if it is not there and the scheme was to roll out immediately, so that provision has been given. Right?
Thank you, sir.
Learned law secretaries from various states, secretaries from the union government, officials, ladies and gentlemen, very good morning, namaskar. I am Ruchi Agarwal. I am Special Secretary Law from Department of Law, Government Entity of Delhi. First, I am going to talk about the special status of Delhi in terms of the legal placement here. Article 239AA of the Constitution of India granted special status to Delhi among the Union Territories in the year 1991 through the 69th Constitutional Amendment, whereby a legislative assembly and a council of ministers was established. The Government of National Capital Territory of Delhi Act was passed in the year 1992, and the Delhi Legislative Assembly can make laws on the subjects falling within the concurrent list and the state list, except entry 1, which relates to public order, entry 2, which relates to police, and entry 18, which relates to land. Also, services is a matter which is out of the purview of Delhi government. With respect to speedy justice, it is reported that there are about 4 crore pending cases in India. Yesterday I was updated, it is 4.82 crores. So nearly 5 crores, and this figure is only rising. So one step towards speedy justice is mediation. Mediation is beneficial because it is time and cost effective. If in addition if the mediation proceedings are unsuccessful, the parties can always go back to the court. It is not binding on a party to just get into a settlement. In mediation, the parties are not compelled to enter into an agreement, and the agreement is arrived at only with the consent of the parties, like I said. In Delhi, there are bi-monthly Lok Adalats also that are held. It is every 2 months. There the traffic cases are taken up. All the compoundable cases that can be taken up in Lok Adalat are also done, even civil matters and family court matters. Delhi courts have optimally utilized mediation as a tool of alternative dispute resolution. There are 6 court complexes in Delhi, and each court complex has a mediation center. A recent mediation center has been opened up in a Rouse Avenue district court complex, which is not a district in Delhi. It is only dealing with the CBI cases, but they have opened a mediation center there as well. There is a mediation center in Honorable High Court of Delhi as well. There are 108 judicial mediators, those are judges, and 197 trained advocate mediators. Since the establishment of mediation centers, the first one opened in the year 2005 in Chennai and Delhi. Until September 2022, 3,16,799 cases have been referred in the mediation center. Out of these, 1,84,472 cases have been settled. This comes to approximately 60% settlement rate. Delhi government also has one of its own initiative for mediation. It is called Delhi Dispute Resolution Society. It is a registered society. It's a wing of Delhi Government Law Department. It provides for pre-litigation mediation. This society has mediation centers in different parts of the city. I think there are about 15 centers at present, and offers mediation services at negligible rates. The reason why this slide I've shown as colorful is because the essence of mediation is non-judicial. In Delhi, they have an arbitration center called Delhi International Arbitration Center, which is under the aegis of Honorable High Court of Delhi. This was also mentioned by the Union Law Minister yesterday. It maintains a comprehensive panel of experienced arbitrators comprising of eminent legal luminaries, including former Chief Justices of India, former Supreme Court judges, former High Court Chief Justice and judges, international arbitrators, former district and session judges. There are advocates, there are scientists, there are engineers who are on the panel, and the matter which is best suited to the particular category is awarded to them. There are about 667 impaneled arbitrators with the Delhi International Arbitration Center. The challenges in legal education. There are many law colleges in Delhi which provide state-of-the-art legal education. However, I feel that LLB, the Bachelor of Law, as a course only provides theoretical knowledge. It lacks the practical knowledge. It lacks our experience in the courts. And then when one passes LLB, one is actually left to go in for a hit and trial method, where maybe one person is sometimes as an advocate is losing a matter, is denting one's career, is not really getting another matter after that. Also, it causes loss to a party. So I feel that to avoid such situations, a course similar to bar at law as prevalent in the United Kingdom can be introduced and made mandatory for 1 year, or it can also be an 8 or 9 months course where law students should be given practical knowledge in an academic structure so that the chances of failures are reduced to negligible. Infrastructure, Delhi has 11 districts operating from 6 court complexes. The CBI courts are exclusively operating from a separate court complex at Rouse Avenue Courts. 144 additional prefabricated courtrooms have been constructed next to 3 existing court complexes at Saket, Karkaduma and Tisazari. There are 5 projects that are still pending for the establishment of more court complexes as well as the residences for judicial officers. The first virtual court was started in the Delhi in the year 2019, which took up all the on-the-spot traffic challans. This was the first court in the entire country, and it was presided over by me only. The first court was actually established in Haryana, but it was not made functional. The first court which was made functional was in Delhi. Thereafter, all the notice branch challans are also dealt with by virtual courts now. At present, there are 8 virtual courts. And one virtual court is able to dispose of about 25,000 challans in a day, while physically a court can only take care of 100 challans a day, that also at a very high level. In Delhi, there are also 34 digital courts dealing with cases pertaining to Negotiable Instruments Act. Here, the magistrates are accepting their pleadings, they're recording evidence, they're having final arguments and giving judgments. It's all happening virtually. There is no physical intervention. The sanctioned strength of Delhi Judicial Service is 482. Delhi Judicial Service Examination 2022 was advertised in February for 123 vacancies, and now there are going to be no vacancies in Delhi Judicial Service cadre. The sanctioned strength for Delhi Higher Judicial Service is 402. 68 officers were recently promoted in April 2022, And now an exam has also been conducted. The interview has also taken place for 45 seats, which are also likely to be filled up soon from the bar directly. Thus, there are not many vacancies in Delhi district courts. The new vacancies that have been created this year are 42 new commercial courts were established, 22 new POXO courts were established, 16 fast-track courts under CSS scheme are already operational since 2019. Total 26 fast-track courts are there, 10 relate to fast-track courts and 16 fast-track special courts under the CSS scheme. There is also a proposal for 10 more additional courts which is likely to be passed soon. Delhi State Legal Services Authority organizes legal literacy programs in schools, colleges, jails, children homes, observation homes, old age homes, resident welfare association and communities to spread awareness regarding the existence of DLSA in Delhi as well as the free legal aid that they provide. In 2021, they had 6430 programs, and in 2022 till now they've conducted 4,202 programs. With regard to the obsolete laws, Delhi has been working a lot on repealing the same. I feel there are 2 more laws that are still pending. These laws have already been sent to the concerned departments for their study, because in Delhi, these laws are actually dealt with the administrative departments. They are not dealt with the law department. So we send it to them, and there's an entire study that takes place to decide if they can be repealed or not. They are still pending. We've sent a lot of reminders. We've personally also pursued with them. Hopefully they should come back to us soon. Yes.
2 inputs on 247 and 252nd report of Law Commission. Please send your inputs.
240?
247 and 252.
I'll see that.
Okay, thank you.
With respect to decriminalization, the department has studied a lot of acts. The 97 were recommended. 65 have been considered as important to be retained, so they will not be decriminalized. 31 have been approved for decriminalization, but they're still under process, and 1 has been decriminalized. With respect to commercial disputes, the Commercial Courts Act has been enforced, implemented in Delhi. There are 64 commercial courts operational in Delhi right now. Yesterday in the figure it showed 22, now there's 64. Thank you.
Shall I start, sir? Sir, I am Achal Sethi, Secretary Law, Jammu and Kashmir. Sir. Good afternoon to all. I have given a detailed presentation, sir. Data has already been shared with central government, so I will not repeat, sir, everything. Only 2-3 points, sir, which are important for us is I'll, sir, highlight it. First, sir, as you all know, sir, by Reorganization Act 2019, our state has been reorganized into 2 union territories, sir. Union Territory of Jammu and Kashmir and Union Territories of Ladakh, sir. So the issue, sir, with respect to, sir, the filling of vacancies in judiciary, sir, we have 65 vacancies of munsifs, sir, which are pending for recruitment, sir. A legal issue has arisen, sir, because as per reorg, we have a common High Court of Jammu and Kashmir and Ladakh, sir. And as per Reorganization Act, there is a Public Service Commission for Jammu and Kashmir, and UPSC is catering the need for Ladakh. So, sir, as it is a common High Court, we have to refer post of Union Territory of Jammu and Kashmir and Ladakh. So, legal question has arisen, sir, whether PSC of Jammu and Kashmir can make recruitment for these posts or not. We have taken up the matter with Sir MHA, and most probably it has been taken with Department of Justice or Legal Affairs, sir. I'll request, sir, if it is sorted at an earliest, so we'll be able to recruit, sir, 65%. Regarding, sir, this repeal of laws, sir, by reorganization itself, sir, we had 334 acts, sir. And at reorganization had repealed many laws, sir. No, we have 129 acts in force. So already, sir, for this, some decision has been taken. And if we are still, sir, in the process of reviewing the laws, if more laws are required to be repealed, we'll repeal it also. We have received, sir, from central government, ma'am, we have received that 4 appropriation acts which have been passed during the presidential rule are also required to be considered for repeal. But at present, ma'am, as you know, ma'am, under section 73, the power for legislation is with parliament only. So we don't have legislation in place as and when, ma'am, because it can be repealed only by legislation. So either parliament can repeal that laws, ma'am, or when legislation will come in force, we'll repeal that.
That aspect. We'll examine that aspect.
Yes, ma'am.
We'll
That we have returned to you also, ma'am. Okay. Regarding, sir, fast-track courts, sir, Pandey sahab, no, sir, 4 fast-track courts are functional there, sir. Even we have less number of cases. It is less than 500 cases for fast-track courts. And UCs are being submitted, sir, online. All the UCs have been given, sir, online. It must be showing on, sir, PFMS portal also. And, sir, so far as judicial infrastructure is concerned, we are receiving sufficient funds, sir. On our part, sir, UC is pending, which we will submit in within 2-3 days, sir. For 75%, we are submitting to central government. But, sir, we have our own, sir, state union territory budget. We have substantially increased. It was 20 crores from last 2 years. No, it has crossed 100 crores for judicial infrastructure. And we are proposing, sir, a new high court at Srinagar also, sir. For mediation, sir, we have established 2 international mediation centers, one at Srinagar and other at Jammu, sir. All over, sir, only 7 rented premises. Courts are running in only 7 rented premises, and we are, sir, constructing the courts by next financial year, sir. There will be no court hall or residential complex, which will be in residential complex, sir. I only want to, sir, draw attention of the department towards one fact that in slide which was shown yesterday regarding family court, sir, that there is no family court in Jammu and Kashmir, sir. Sir, actually Family Court Act was not applicable in Jammu and Kashmir. It has been made applicable in 2019. After that, sir, we have established 2 courts as per the population of this. So this is, sir, only from my side, sir, if some observation.
Please send inputs with respect to 4 law commission reports.
Ma'am, I'll submit, ma'am, in that. Ma'am, actually, our constitutional position, were different before 2019.
Yeah, that's the
So we were examining the report in context of that only, ma'am.
Okay, yeah.
So we have to again put up, and as we are no union territory, we should not have any objections to that. Okay. So we'll examine that.
Okay, okay. You examine and send your
yes, ma'am.
comments
sure,
on that so that we
within
can...
a month or so we'll
okay, sure.
Uttarakhand, I am Law Secretary. Good afternoon to all. I do not want to go much in detail because I know that we are already running short in time. So actually the first point is the mediation for speedy justice. So there is no specific time was given to us. So I have gathered the data of last 2 years from 1 July 2022 to 31st July 2022. The cases which were referred for the mediation during these 2 years, 106 cases, only 10 cases were successfully settled through mediation, and 60 cases were unsuccessful. We have also provided 40 hours training to our 19 advocates and mediators. The number of mediators presently in our state is 90. So it's a good number, though we are a small state. For the arbitration ecosystem, the arbitration matters, generally it is in our High Court. So during the last 2 years, our High Court have appointed in 143 cases, arbitrators were appointed, and total number of arbitration cases disposed of the same number, 143. Now I will go through directly on the upgradation of infrastructure of the courts. Total we have 236 court halls, in which 215 are owned by the judicial department. 18 number of courts are running owned by the state government, like Tehsil, etc. And 3 courts are running in rented premises, and 67 courts are under construction. we are getting a very handsome amount of funds from the centrally sponsored scheme. Under e-court and digital courts, we don't have any paperless court in Uttarakhand. The digitization process in the High Court have completed till the year 2015. And now we are, there is a proposal to reinitiate the process of digitization of pending and remain disposal cases in progress. After reinitiation of the digitization of pending cases, the process for paperless court shall be initiated. The main problems with regard to the e-court project is the major part of the local area network, servers, the computers, other computer hardwares in High Court and subordinate courts have been provided. They have become either obsolete or not sufficient. Inadequate technical manpower for managing the ICT related work in district headquarters and outland courts is also there. So there is a need for sufficient number of skilled technical manpower to be made available in High Court and subordinate courts. I will submit this the hard copy to the law department. We have categorically given the details in the number of manpower which we require at the taluka level and the district headquarter level and the High Court also. So we need some programmers, system assistants and network engineers in our state. Now I will go to the agenda point vision for 2047. Disposal, number one is the disposal equal to institution, time-bound justice delivery system, that is speedy justice, justice at minimal cost means affordable, society-centric and doorstep justice delivery system, technology-based, simple language of court proceedings and orders and judgments to facilitate the parties to reach on their own judgment. So far as the fast-track courts are concerned, we have 4 fast-track special courts who are dealing with the cases of rape and POXO cases. We don't have so much pendency in all the districts of Uttarakhand. The main pending cases are in the districts which are there in the plain areas like Haridwar, Dehradun, Udham Singh Nagar and some part of Nainital. At present, no report of the Law Commission is pending in our state, and the question of the Lok Sabha question, there is no pending. The ministry have pointed out that the one question of religious trust is pending in the Uttarakhand, but the information is not correct. Yes, I have received that question, and we have responded that the matter of religious trust does not relate to the law department. We have responded to our Chief Secretary in this regard. So far as the obsolete laws, we have repealed one Sarai Act 1867 in the year 2017, and one old act is there, Dehradun Act 1917, and we are in the process of repealing that act. Soon that will be repealed. One is the ease of doing business. So we are facing some problem from the finance department in establishment of new commercial courts. We have proposed a new court for Haridwar who may deal with all the cases of Garhwal region. But now they are posing a query that please give us a minimum number of cases, the standard for which a new commercial court may be established. So if some data or some standard is given to us, then we will try to convince the finance department for the establishment of a commercial court. So only we have one commercial court functional at Dehradun.
Perhaps, sir, all these queries, all these aspects have been raised by you yesterday?
That have been raised by our minister.
Why are you repeating today?
Okay. The suggestions for the speedy justice is most of the cases are pending in the criminal side, and cases mostly pending in the at the stage of recording of evidence, that is 58.66% cases. So if we can take the services of retired judicial officers for the purpose of recording evidence in criminal cases, this can be done in temporary makeshift courts for which funds may be provided by the central government to all the states. When the recording of evidence is completed in the cases, then the case may be transferred to the serving judicial officers for disposing and delivering the judgment of the matter. This will result in speedy justice of the criminal cases in the time-bound manner. The system of execution of summons and warrants of witnesses and accused should be improved in order to cut the delay in procuring the attendance of witnesses and accused. The service of summons may be effected on the witness through electronic mode, or in cases where the witness residing at the place of long distance, then his evidence may be recorded through video conferencing mode. In civil side, it has been experienced that the cases do not attain finality due to various provisions of revisions and appeals. The procedure of execution of cases is also very lengthy and time consuming. So it is suggested that the Civil Procedure Code may be suitably amended. The right to appeal and revision should be restricted so the judgments may attain finality. The Order 21 of Civil Procedure Code dealing with the execution of decrees may also be amended. In so many matters, the police may be directed by the civil code for execution of its orders like delivery of possession and immovable property. One aspect is the budgetary support the states by the central government. The administration of justice, constitution and organization of all courts is in the concurrent list of 7th schedule of the Constitution of India. The financial condition of small states like Uttarakhand is not very much in good condition. So the states are reluctant in establishment of new courts. The main reason behind is the recurring expenditures like salary of staff and judges, maintenance of court buildings, expenditure on computer hardware and software. Therefore, it is requested that the central government may provide lump sum funds to the small states like Uttarakhand. This will help the states in speedy disposal of pending cases and quicker delivery of justice. One more thing, Mr. R.S. Verma, which you were mentioning, why I am repeating the things. I am not repeating the things because my minister is told not about the commercial court. He was quite confused. He was told about the virtual court. So I want to correct here.
Okay.
1 minute.
You finished?
Achha,
with respect to Uttarakhand, though, you said that one act is to be repealed and you are examining. There is one question, parliamentary question on trust for religious places.
Related to the law department. We do not look after the affairs of religious trust. So we don't have any information with regard to religious trust.
Any other officer?
Good afternoon, everybody.
Okay.
Short.
Sir, I come.
I'm Jaswinder Kaur.
I'll come.
I'm Secretary, Home Affairs, Punjab. We prepared a detailed presentation giving all the facts and figures and achievements, but then due to shortage of time, I don't think we would be able to run through that. So I'd just like to highlight a few points. One from the agenda. One is regarding upgradation of infrastructure of the courts. So a budgetary allocation in this regard has been made under the CSS. It is 45 crores is the state, the central share, and 30 is the state share. So we already have about 139 projects which are in the pipeline.
Or else shall I send it mail from my side subsequently, tomorrow or day after tomorrow? Sir?
Okay. 139, the Honorable High Court has given a list of 139 projects. So we are short on funds. So I would request that we should be allocated more funds for the infrastructure. As regards fast track special courts, there was some problem in mapping, which has been sorted out very recently, and in 2.5 crore has been received, and now it is showing on the portal. More funds are to be released by the center for the fast track courts. There were vacancies in the state. Now 25 additional session judge posts have been created, 80 of civil judge junior division, and we've advertised 159 posts very recently. As regards religious trusts, we sent the report. It is nil, and the state is has issued guidelines for speedy trial, and there are some very good practices being followed by the state, which is also in the presentation. as regards repeal of obsolete laws, uh, we had, in our list there were only 2, but now we've received the agenda in which there's a large number.
25 acts are there.
Yes. So our previous list of 2, we are working on that. So even these are pending, the list which is in the agenda. So I found out this is pending with the finance department. So I will go back and have it expedited. That's it. Thank you.
Thank you. Anybody else?
Regarding release of fund, madam, which you have told, actually we are waiting. We are here waiting to release the fund, but it is the compliance of PFMS, because of which everything is just standstill. Right. Please go again and see if compliances are clear. To our knowledge, it is yet to be cleared. Right. So if it is clear, immediately we will release the funds. Because of those, if it will not be compliant, then CSS funds, either it is infrastructure or FTSC, that will remain the same. So please go, and again, if there is any obstruction left, immediately that should be cleared and we will release the funds.
Right. Thank you.
Sir, this is Secretary Law, Sikkim. Sir, I have submitted my presentation, but it is, my presentation is with regard to the achievement and the compliances of the state government. So I don't want to dwell upon all those presentations. I just like to make a few suggestions, if I may. Before that, I would like to say that mediation is doing well in Sikkim. We have 51 trained mediators in Sikkim. And as of now, we have disposed of 1,084 cases through mediation, and 51 cases are still pending in the mediation centers. So we are doing well in mediation. With regard to this mediation, if I may suggest 2 points. Number 1 is pre-litigation mediation may be emphasized. Second point is, if we can make a provision where we can impose certain kind of fine to the parties if they don't settle the dispute in the mediation. Like I may be permitted to cite one example, like in this recovery cases, the defendant is offering 50,000. Let's take an example. The defendant is offering 50,000 to the plaintiff, but he refuses because the lawyers comes into picture, and they will definitely resist to all these things, and they don't want to settle the dispute in the mediation. So if the defendant is offering 50,000, if later on, if the plaintiff goes back to the court, and if he gets less than 50,000 from the court, then he will have to pay something. So that way we can compel them to come before the mediation and settle the dispute. Otherwise, what the parties are doing, they are coming before the mediation just to pass the time. 3 months will be over, then they will again go back to court, again start fighting. So if this suggestion can be put in a kind of, provision kind of thing is put in the Mediation Act, which is being, which is being brought by the Ministry of Law and Justice. This could help the settlement of the disputes through mediation in a better way. Thank you.
Any other officer?
Good afternoon. I am Shankarlal Dutta, Additional Law Secretary, Tripura. So though I have
Law Secretary, Tripura.
Additional Law Secretary. Though I have a long presentation to make, but I will cut it very short. Actually, I will touch upon only on important points. Regarding alternative dispute resolution mechanism, it can be an important tool. Mediation can be made popularized in the states, because in Tripura, the success rate on mediation is not up to the mark. In Tripura, there is only 116 mediators and only 55 cases are pending. Regarding mediation centers, we have only 5 mediation centers, and we are going to establish 3 more mediation centers in rest districts. Regarding Lok Adalat, Tripura has improved a lot. If I go on data, for last 5 years, in 2021, the settlement of disputes on Lok Adalat on pre-litigation matters, 806 matters were disposed, and post-litigation matters 55,417 cases were disposed through Lok Adalat. In 2020, 26,095 cases were disposed. In 2019, 90,786 cases were disposed through Lok Adalat. In 2018, 1,39,931 cases were disposed in Lok Adalat, and in 2017, 1,69,763 cases were disposed. So there is a lot of improvement in settlement of disputes through Lok Adalat in Tripura. Regarding establishment of ADR center, sir. Sir, we have only one ADR center at Agartala. So we need to establish ADR centers in other districts, sir. And for that, sir, if the Ministry of Law and Justice considers for fund, so we can establish ADR centers in other districts, sir. Regarding repealing of obsolete laws, Tripura has repealed 222 cases, acts. And regarding decriminalization of laws towards ease of doing business, Law Department has constituted a committee, and committee has identified almost 16 acts for decriminalization, and the committee also identified 12 numbers of rules for decriminalization. Regarding speedy disposal of cases, I think speedy disposal depends on performance of several stakeholders. And for speedy disposal, there is High Court who is looking after for proper disposal of cases in a speedy manner. And regarding the filling up of vacancies, Tripura in grade 1 cadre there is only one vacancy, and that arose because of creation of one post. There is no vacancy in grade 2 cadre. In grade 3 cadre there are 13 vacancies, and I think the 13 vacancies are going to be filled up this year. So there will be no vacancy in Tripura. Regarding fast track special courts, we have, I think there is one Supreme Court judgment, and according to that judgment, fast track exclusive POXO court is to be established on, in district where there is more than 100 cases. So in Tripura, in Agartala, in West Tripura district, there is only cases more than 100. So in Agartala only there is exclusive POXO court. In other districts, we have constituted fast track courts. Only 2 fast track courts, and in 5 districts there are the number of cases are very less. So there is no exclusive POXO court. Regarding virtual court, in Agartala there is one virtual traffic challan case court, and in the matter of excellence of laws, recently the Honorable President of India has inaugurated Tripura Judicial Academy on last 12th of this month, and we are also going to establish one National Law University at Agartala. We have one government law college, and we are also going to constitute one more law college in Tripura. Regarding telelaw, we received a good response in this field. Telelaw data shows that in 2022, we total 10,127 cases were registered on telelaw, and advice were given on 9,970 matters on telelaw. And last, in the matter of drafting of legislation, actually, madam, there is problem that when judicial officers are posted in law department, they are transferred in a periodical manner. But we have only 2 officers, 2 permanent officers who remain in law department. So if these 2 officers are trained on how to draft legislation or how to point out the defects in legislation. So this can be useful.
You can send them for training. What do you say? They have to be trained. Yeah, you can send them for our training institute. And then I request your inputs on 2 Law Commission reports, 194 and 235, that is pending from Tripura. 194 and 235.
Okay, we will look after, ma'am. And we on PFMS. Actually, we are facing this issue because of non-submission of UC on PFMS. Because our technical staff, according to report of our technical staff, they are unable to submit UC on CSS matters. And accordingly, on that, we wrote to the Department of Law and Justice by email on 1st August 2022 that we are unable to submit UC. So this matter can be looked into.
Regarding submission of UC, what you have raised, actually in existing system that facility is not there, but you submit UC in physical form, but at the same time, if expenditure will be reflected, then immediately fund will be released. If unspent balance is not there.
It will be sufficient if we submit
exactly
UC in physical form.
Yes, at this moment, since UC is not being uploaded on the system PFMS, we will take it up with central PFMS. Till that time, just physical form UC may be submitted, but on the SNA 19 and expenditure column, it should reflect properly, so that unspent balance should not remain. If it will not be remaining, less than 25% of the loss release will be there, then it will enable us to process for release of funds. So expenditure column must reflect. What is happening is that in expenditure column, it is not just getting reflected. So unspent balance is there. If unspent balance will be there, that will not enable us to process for release of funds. That is the main issue. So UC part, you may submit it in a physical form, but so far as PFMS compliances are concerned and those SNA 1, 9 and those columns expenditure must get reflected properly. Right?
Thank you, sir. Any other officer, sir?
Good afternoon, sir.
We have already listened you, dear. Whatever your problem, you may give in writing.
But I did not submit. Shall I submit my paper?
So please give it in writing to our officials.
So one thing, sir. Earlier we had 10 districts. So now we have 33 districts in our state, and we have started operating 34 POCSO courts. So and the only thing is now in all the 33 districts, so the state government has granted the lands. Now we have to go for the buildings. That is the infrastructure development has to be done. So that is the other aspect, sir. And one more aspect I would like to regarding the disposal of cases and speedy disposal of cases, sir. My suggestion is that, sir, as we have been constituting a fast-track special courts for disposal of the POCSO cases and the special courts for the rape cases, special fast-track courts have been constituted. So also, in the similar lines, if we can constitute a special court for the senior citizens. So I hope that most of the senior citizen cases would be taken on the priority basis and that can be disposed. So we have, sir, there are commercial courts have been established in our district, and it's regarding the vacancies, sir, we have already, the Hon'ble High Court has notified the recruitment post for the district judges, direct recruitment, and also the junior civil judge, and it is under process, sir. And it is going to be filled up within a period of, by the end of this year. And regarding the mediation, sir, we have mediation centers in 10 districts, sir. And the only thing is that we are now planning to go for the mediation in the other districts also. We have our trained mediators, our 348 mediators in all the districts, and 120 judge mediators and 228 advocate mediators in the state. Thank you very much.
Just one clarification. These fast track courts you have raised, fast track courts for senior citizen. I would like to attract your attention regarding the concept of fast track courts as recommended by 14th Finance Commission. Courts have been earmarked to the states, and those courts will try the matters of heinous crimes, crimes related to women, children, as senior citizen. So senior citizen is covered under fast track courts if you will see the FTCs as recommended by 14th Finance Commission. As you have told that fast track special courts like rape and POXO Act cases, yes, certainly another one dedicated scheme is there, centrally sponsored scheme, but senior citizens are also covered under fast track courts. That can be taken care of, right?
I hope that discussion was held in a very smooth manner and in a cordial manner. So anything else which is you feel very important, kindly tell it, but in briefly, because it is a timeline given to us, so we may adhere to that also. Please, whatever your submissions, you may tell.
Only one question I want to put with regard to your reference, that since the Andaman and Nicobar Islands does not have that much of number of commercial cases, so only 1 or 2 cases are there having the jurisdiction of money value of 3 lakhs and above. So in that respect, it is my question whether it is essential that the commercial courts exclusive should be built up.
Perhaps it is a matter of policy. Perhaps it is a matter of policy because we have not to decline any individual from the justice. Speedy justice for one also. So you may create a fast track court, but later on may shift additional burden to that fast track courts. As is seen in other cases also, whether we have seen that CBI special courts also deal with other cases. So there may be a mechanism. And
one more question relating to the same thing is that suppose a decree has been passed by a commercial court, then who will execute the same? Because there has been no Nazir. There has been no Nazir in the district of Andaman and Nicobar Islands in the district administration. So, how the decree would be executed?
Sir, it is again a question of administrative in nature. Posting of Nazir, you may consult with your concerned High Court, sir. And
can it be meant to be the district Nazir of the civil court? Can it be meant?
I'm not expert in that, and really speaking,
that's why I want to have this doubt clear in your mind.
I have not gone through that Commercial Court Act till
yes.
now, so I'm not well acquainted. But perhaps your question is well taken, and we will explain.
Okay, thank you, sir.
Excuse me, sir. If I'm allowed, I can add on that. Actually, in commercial courts, I think the most cases are related to arbitration proceedings. So in the matter of arbitration proceeding, arbitration award will be passed. So the arbitration award is treated as a decree, and it can be executed like any other decree of passed in civil cases.
Commercial court decree.
Yes, but the award passed in arbitration matter is treated as decree.
Now, communication has been made from the Center, Department of Justice, that that should be sent to the district Nazir for execution of the same. But there happens to be no Nazir in our district administration. That's the problem we are facing right now.
Every arbitration award, these are executed in the same manner.
That is well known. That is not a question.
That will be addressed. That will be addressed. We have, our persons have noted this. We will take it.
Hello. Hello. Is there any other state which has to put forth his views? Otherwise, we'll proceed further.
A small query actually. So since all the UTs are here, recently the panel was shifted to the Supreme Court for all the matters which were taken up at the level of Supreme Court. And we are facing a lot of problem on that regard. Our cases are not being taken up. So I wondered from where should we take it up? I mean, we have been writing DO letters to the Secretariat and everyone, but we are having a lot of problem with our Supreme Court matters. And I don't know what is the experience of other UTs, but Chandigarh has been facing replies are not being filed, it's not being followed up, and suddenly the pendencies, earlier the panel used to be recommended from the UTs, but now it has been taken directly at the level of the center.
Please, sir, Mr. Yadav, repeat your question. I couldn't understand.
So the panel earlier, the panel of advocates in the Supreme Court for the cases which are pertaining to the concerned UTs used to be dealt by the advocate panels which is recommended and selected at the level of concerned UTs earlier. Now it is selected at the level of the Supreme Court's committee which is there. So there is no say of the UTs on who is the advocate which is being allotted. So we have been just given a letter that transfer all the cases to the concerned panel of advocates which has been selected at the level of the Supreme Court. So now we have no control over the cases which are being listed there and are dealing with the UTs in Supreme Court. So who would be dealing with these matters?
In Supreme Court, there is a central agency section.
That's so.
There is a central agency section which is looking after the litigations pending before Supreme Court on behalf of Government of India as well as on behalf of the UTs also.
Yes.
So there is a panel.
Yeah.
There are three types of panel, panel C, panel B, panel A. And in addition to that, there are additional Solicitor General, and some important cases there is Attorney General.
Yes.
So you, perhaps your query is with regard to identification of the advocates to whom your case are being marked. So whenever a request came from your side, so that is marked to any advocate which is in the panel.
Right.
So then and there is an information system, LIMS, so you may get information.
So what is happening is the central agency section is allotting the work to someone. So we only know the nodal advocate. So we come to know that the X advocate has been allocated. But it's so difficult to track them, whether they are working or not. Earlier, the panel used to be selected at the UT level. So we had direct control over them. We could remove them. We could take action against them. But now, only the central agency section is allotting it. So we keep writing to them that this case is not being sent, this advocate is not performing, and nothing happens. So ultimately, the cases are being, not dealt with. And
it's the same thing we have faced also. I second him on this aspect. Suddenly, one letter has come to us that henceforth all the cases should directly be sent to this organization or these advocates.
Hello. Sir, we had taken note of your concern.
Yes.
We'll put this issue before our higher-ups and we'll come back to you.
We are in a fix as to the norm of the law. Yes, how can we contact
kindly send
him?
the letter to our law secretary.
Yes.
The matter will be,
Yes, we have made several correspondences with the department. But all of a sudden we have given a notice that henceforth the cases shall be transferred and communication should be made to these advocates.
Sir, that's what I am requesting, that
Yeah.
we had taken note of the issue raised by you. We'll try to sort it out.
So
Thank you.
My only limited question was who would be dealing? Because that letter has just come. So obviously the central legal section, they are not handling it. So should we, approach Secretary, sir, legal affairs?
I'll put this issue before the learned law secretary,
Right.
because he is the in charge of Department of Legal Affairs, so he'll take care of that.
Thank
you. So if you all permit, may I proceed further? Thank you. So, ladies and gentlemen, we conclude the breakout session for the states. Next agenda would be validatory session, wherein the Honorable Minister of Law and Justice would be delivering his address, followed by vote of thanks by Honorable Minister of State for Law and Justice. Thank you. After few minutes, all the delegates would be assembled here only. So conference hall number 2 and 3 delegates would be arriving in conference hall number 1, wherein we'll proceed towards the valedictory session. Announcement, I would request all the delegates to please don't leave the keys in your respective cottages. The keys are to be handed over in the reception. Thank you.
Check.
जी। Hello. It's an important announcement for all the delegates. Please don't leave the keys in your cottage. Kindly hand over the keys at the reception. Thank you. A feedback form has been given to all of you. All are requested to kindly give their feedback in the form. Thank you.
AC is very
Hello. Namaskar and a very good afternoon to all. I take this opportunity to once again welcome our distinguished guests, friends and colleagues to the Validatory Session of All India Conference of Law Ministers and Law Secretaries organized by Ministry of Law and Justice. The Iron Man of India, Sardar Vallabhbhai Patel said, "Manpower without unity is not a strength. Unless it is harmonized and united properly, then it becomes a spiritual power." Following the footsteps of the great leaders of the soil, the Ministry of Law and Justice organized this conference of all the law ministers and law secretaries from the states and UTs of the country to facilitate communication and enhance mutual cooperation between the center and the states as well as among the states. This conference also aimed to further exercise to envision India 2047 being undertaken by Government of India. We consider this conference to have been very successful and to have advanced us closer to our ultimate objective. It gives me immense pleasure to state that All India Conference of Law Ministers and Law Secretaries has been a great success. The delegates in the two-day conference were able to exchange views and deliberate upon a broad range of issues pertaining to law and justice in the country. Topics for discussion ranged from repealing of obsolete laws to reforming legal education system in the country, harmonized working between the center and the states, ensuring speedy justice by promoting innovative measures such as arbitration, mediation, fast-track courts, access to justice, tele-law, and e-courts and digital courts, and so on. There were exchange of ideas on the probable progressive steps to bring in the future we want for the nation. Now that we have come to an end of our 2 days conference, now it's time for us to adopt the resolution which is an outcome of the deliberations in the last 2 days conference. We have kept a copy of the resolution at your desk. Would request all of you to take a look at. If you all allow, let's adopt it. May I now request our Honorable Minister of Law and Justice, Shri Kiren Rijiju, to deliver the address. Thank you.
Thank you very much. My colleague, Minister of State for Law and Justice, SP Singh Bagelji, Honorable Law Ministers of the States and Union Territories, the learned law secretaries, and the participating delegates. We all arrived here day before yesterday, and some of the delegates arrived yesterday, and our Honorable Minister Law and Justice from Puducherry arrived and joined us this morning, and some of our colleagues had to leave little early because of the flight and other issues. But by and large, I'm very encouraged by the participations of the Honorable Law Ministers and the Secretaries. As I mentioned yesterday, we are having this meeting after a long gap. So it is a learning experience for us, and also to ensure that the next meeting will be based on what we have discussed here, decided as suggestions, observations, and as part of the resolution. We will definitely improve upon all our efforts in the next coming conference. Next year, we will select another beautiful location so that not only the discussion is very fruitful, but the stay also remain memorable, and we can, wherever we go, we should enjoy the ambience, the locations, the culture, the people, the food, everything. That is how human life goes. We keep learning, we keep discovering new things. India, as a very large and diverse country, we have so many things to see within our country. So our Honorable Prime Minister Modi ji also keep on insisting that while we tend to see abroad, when we try to go to the foreign countries and enjoy the beautiful locations, we have so many things in our own country to explore and to learn. If we know about ourselves, it is always better to understand ourselves. India is such a blessed nation with so much of diversity, diverse culture, so much of heritage, ancient heritage which we have. We must celebrate our beauty and our strength. In this 2 days conference, technically 3 days, we have deliberated upon many issues. I have personally gained lots of informations from the colleagues, the law ministers and the learned secretaries. And our officers in the Ministry of Law and Justice also had made very good presentations. I'm sure you must have got certain benefits out of the presentations and also got some new ideas what else to do. In the same manner, the Ministry of Law and Justice also has able to capture many things from the good practices which our colleagues in different states and union territories have adopted. There are many issues which came into the fore. Some of the oral observations also, I have taken note of that. Our ministry officials have taken note of all these suggestions. There are some issues where we need wider consultation, we need more deliberation, and we have to adopt the consultative process. We believe in federalism, and without the consultative process, things cannot reach the logical conclusion. Yesterday, Honorable Prime Minister made certain very important points during his inaugural address, and I'm sure we are on board. One point which I would like to emphasize is we need to have better working relationship and better coordination with the judiciary. Some of the issues are a bit sensitive as well as which requires a deeper deliberation. India is a democratic nation, and we have the guidance of our constitution in discharging our duties. Our strength and our source of our deliberation as well as our conduct flows from the Constitution. Constitution is a sacred book, and we all believe in the Indian Constitution. At the same time, the sovereignty of the country lies with the people of India. In Constitution also, we have said the same thing in the preamble. It is we, the people of India, who have given ourselves that power. So from the sacred document of the Constitution, we can say that the ultimate sovereignty lies with the people of India. And people of India elect their own government. And through the elected government, we discharge our constitutional duties and obligations. As Prime Minister had mentioned, if we all stick to our roles as per the Constitution of India, there is no scope for any conflict, or in the common language, I can say there is no scope to fight for the turf. There should be no reason for judiciary and executive, and to that extent, the legislature to fight for the supremacy. But the problem starts when we venture into each other's territory. I had mentioned this point in the Chief Ministers and Chief Justices Conference, and also on the Constitution Day on 26 November, I had repeated this point, that we, the Government of India, respect Indian judiciary. In our 8 years of our tenure during Modi ji's government, we have not done anything, we have not taken any steps which would undermine the independence of judiciary. We will continue to honor the Indian judiciary, and we will continue to respect the judgments and orders which come from the courts of India. At the same time, we have also very clearly sent a message that the judiciary action and all judiciary pronouncement should not lead to encroachment into the domain of the executive and the legislature. In the parliament also, we have been very careful while deliberating on various issues. We are careful of not undermining the Indian judiciary. We are very frank while we put across our point with the judiciary, and we will continue to raise certain issues with the judiciary, because without the cooperation and coordination between three organs of the state, we will not be able to provide justice to the people of this country. Some issues which came up during the deliberation yesterday also and today also, I have taken note of those points. Our officials from the Ministry of Law and Justice have taken note of those points. The resolutions which have been tabled here before you, you have gone through it. We will be passing this resolution. And also, we will also ensure that the points mentioned in the resolution or those points which are part of the discussion are given proper attention to. And I would also see that wherever necessary, the interventions or the support from the Government of India, we will ensure that the states and union territories are given proper support. And whenever I visit the different locations in our country, I try to meet the state government officials as well as the judges and other judicial officers. Some of the vital issues which I could recall are the legal education which we have in our country require some kind of more deliberation, but I'm not putting that into more than what we have done, is because we will have to have the Bar Council of India, different bar councils of the states into account. They have to be on board. And in our country, these days, some of the matters become very sensitive. Even when we discuss things, it becomes a little touchy for the other stakeholders. And we will never undermine all the stakeholders. Sometimes we should also hold this kind of gathering with the stakeholders like the law universities, the academicians, the bar councils, the bar associations, and the judges. When I meet with the judicial officers, I try to know more from their side, their perspective, and also keep our perspective. What we have discussed in our course of deliberation is more about what we do and what we think from our side, from the government of the states and union territories and the union government. There are different viewpoints on the same subjects from the judiciary side also. So we will have to take everybody on board. One matter which I want to point out is the Honorable Minister from Tamil Nadu also pointed out today about the online gaming. Now, e-sports, you know, e-sports is something which has been recognized in the Asian Games, and it is also going to be there in the Olympics. E-sports are played online only, but it is not gambling. So some of the states have already taken certain steps on banning the online gaming. But since e-sports is a reality, we have to take a call. I would be writing to all the state governments, so I would also expect a positive response from the state governments on e-gaming, because India being the largest democratic nation, and very soon we are going to be the most populous state, most populous country in the world. If we go for another census, who knows, we might have already overtaken the People's Republic of China in terms of most populous nation on the planet. So as a large nation, India's presence in the digital world is going to create huge impact globally, not only within the country. So we need to have a law considering the reality which we are facing. There are many more subjects which I would be writing to the state governments. Recently, I had written a letter to the Chief Justices of the High Court about the fast-track courts. Some of them have personally called me and informed me about the various steps they have taken. But there are certain gaps which I see. That is the coordination between the high courts and the state government. While appointing the judicial officers, the judges of the district courts, subordinate courts, the high courts required to take much more close coordination and much more effective steps in terms of coordination with the state government. Some of the state governments feel that they are just doing very paperwork only, not having actual any kind of more participatory role in terms of appointing the judges of the lower courts. In the high courts and the Supreme Court, central government is an important stakeholder. And finally, it is the state government which signs the document and releases the appointment order. The warrant of appointment is signed by the Rashtrapati after the law minister and the prime minister signs the file. So we have a collegium system which is working since 1993. Before that, the government was the sole authority to appoint the judges. The only thing they used to do was to bring the matter in the knowledge of the Chief Justice as a consultation process. But after 1993, this process was revised and a collegium system came into being. So since then, the collegium system is going on. I know some of the high courts have issues of pendency. We have been very honest in terms of discharging our responsibility. I have also informed that day also that during our time, yesterday, our Additional Secretary Justice also mentioned that we did record numbers of appointments of judges in the high courts. And this year also, we are going to, I'm hoping, create a record kind of appointment for judges in Supreme Court and high courts. I personally want the vacancy level to come to minimum level. When I took over as the Minister of Law and Justice, the pendency, the vacancy, these were large issues. So in the high courts, we could bring down the vacancy to the large extent. And last year itself, in 1 year, we appointed more than 250 High Court judges. And now the pendency rate is much lower than what it used to be. And in Supreme Court also, we have 4 vacancies right now. I'm hoping that very soon we will be able to fill up all the vacancies. Of course, I'm already in touch with the Collegium in the Supreme Court, and we are taking necessary steps. As far as the infrastructure is concerned, some of the states, by virtue of being more revenue surplus or better avenues to get the resources, they have created better infrastructure for the judiciary. Some of the states have little lagging behind in terms of providing adequate funds. We know the reasons. All the states and union territories of our country are not in same page in terms of revenue collection, in terms of resources. Central government will definitely chip in wherever it is necessary, and especially for the lower judiciary, we have a committed scheme called Central Sponsored Schemes, which many of you are taking good avail of that scheme. Some of the points raised by the honorable ministers, as I said, it will take time if I respond point-wise, but I have taken note of all those things. Technology is one important thing. I think every state and union territory has really put into good use. The high courts are very proactive in terms of making their courts paperless, and through video conferencing they are able to take many more cases and also disposing them off. The alternative dispute resolution mechanism, I'm happy to note that all the states and UTs have taken great steps in creating arbitration centers, mediation, and also there are some issues where at the local level, especially in the scheduled areas, some local customary practices are put into use still very much, and which helps in reducing the numbers of cases going to the regular courts. One aspect of what I have seen in terms of delaying of utilization of the funds is the PFMS. Our Secretary of Justice is in touch with the state governments. We really need active involvement of the State Finance Department. We have also urged the Chief Ministers to personally involve in it, because the public fund monitoring system is something which we cannot ignore. This is the practice which we have put into use. Many states and UTs are not able to get funds because of this issue. So once again, I would like to urge all the states and UTs to get in touch with the Department of Justice to sort out this issue so that we can utilize as much as possible all the funds allocated. Because I need to go back to the Finance Ministry for more funds only if we can utilize all the earmarked budget. So last year also I tried my best to ensure that all the states and UTs utilize the funds. Regarding the quality of lawyers and quality of judges, it all depends on our legal education. If we have good universities and good colleges, we will get good lawyers and good judges. Frankly telling, when we are considering the name of the judges, it is very difficult. And some of the reports, some of the observations we receive from the consultee judges and from the chief ministers and governors also, from our own departmental inquiry which we conduct, we found so much wanting in terms of the requisite necessary attributes required for a person to become a judge. Now, I don't know about the lower judiciary, many issues have come up, but to be judge in High Court and Supreme Court, one must have the requisite attributions. So for that, we really need high degree of the standards in our legal education in our country. I have many more points, but I think I will cut short about the issues which I have said that we have taken note of all the issues. Personally, I am very happy some of the honorable ministers have stayed on from the very beginning to the end. Some of the ministers could not reach. In some states, the chief ministers are holding the portfolio of the law department. They could not come, but we have good presence of good numbers of our honorable ministers. We have full participation of the law secretaries and officials from all the states and union territories. Very soon I will be visiting some of these states. I will meet you there once again. But please keep in close touch with the department. For all the judicial matters, keep in touch with the Justice Department. All the legal matters, please keep in touch with our Department of Legal Affairs. And the Legislative Department, as the presentation has shown yesterday, we require much more coordination because we need to not only improve the standards of our piece of legislation, but also to simplify and make a proper, simple laws which are good for the country and good for the common people of our country. I always strive for this. Make simple laws, make appropriate laws, remove all unnecessary, unwanted, undesirable laws. Our aim and objective is simple, not to put unnecessary burden on the common people by enacting unrequired laws, but by removing all those obsolete laws, redundant laws, and throw them out of the statute books so that we become more lean, thin, and more smart. Our legal system must be smart, our judiciary must be robust, and for that we will have to come together. This is a very important conference. We determine so many things. And as I said in the beginning, that Prime Minister has laid down a very strong ground to make India a rich and developed country by 2047, when India would be celebrating our centenary years of the independence. India must be not only prosperous, but fully developed by any standards, by any yardsticks which the global community accepts. So for that, we will have to have a responsive and collective actions from the Ministry of Law and Justice, as well as all the law departments of the states and union territories. I would like to thank my colleague, Professor S.P. Singh Baghel, Secretary Legal Affairs, Secretary Justice, and Secretary Legislative Department, and all the officials for making this conference a worth conference, and also the state government of Gujarat, who have been very proactive in terms of hosting such events. Whenever I have come here, the Gujarat government and their various departments have been extremely cordial and very helpful. So it helps us in conducting such events. My special thanks to the law ministers of the states and UTs for making your presence here and also in contributing immensely in the success of this 2 days conference. My special thanks goes to the law secretaries and their team of committed officers who have made this conference not only successful but memorable one. You have seen the surroundings of this Ekta Nagar. This is a historic city now. It is a small location, but it has for all purpose all the amenities for anybody who wants to come here and explore not only the Statue of Unity, but the whole of Ekta Nagar. I feel proud that I was part of this whole effort with my humble contribution of metals collected from all the villages of my state in sending here to be part of this great tallest statue in the world, the Statue of Unity, the statue of Sardar Patel, the first Deputy Prime Minister and the Home Minister of our great country. So these kind of locations, these kind of efforts are not only a matter of symbol, but a matter of great inspiration. We draw inspiration from the great souls who have made our nation great and who have given a right, perfect platform for us to take our great nation to a new height. Thank you very much, and I hope to see you once again very soon in different locations, but hopefully in next conference of the law ministers and law secretaries. Now I request my officers to do necessary things for the passing of resolution and also for the vote of thanks.
Thank you, sir. Your support and guidance is unparalleled. May I now request Honorable Minister of State for Law and Justice, Professor S.P.S. Baghel-ji, to propose vote of thanks. Okay. As I had already told of you that we had attempted a resolution which has been placed on your table. So now let's kindly raise your hands and adopt the resolution. Thank you, all of you. Thank you so much. Now we declare the conference closed. Thank you. Sorry, before that, I would like to request Honorable MOS to propose vote of thanks.
पूरे देश के लॉ मिनिस्टर्स और लॉ सेक्रेटरी की इस कॉन्फ्रेंस में पधारे। भारत के लोकप्रिय विधि एवं न्याय मंत्री श्री किरण रिजिजू साहब, सेक्रेटरी लीगल अफेयर्स डॉक्टर नितिन चंद्रा जी, सेक्रेटरी डिपार्टमेंट ऑफ जस्टिस श्री एस.के. जी राहटे साहब, राज्यों के मौजूदा मिनिस्टर्स, तमिलनाडु से पधारे श्री एस. रघुपति जी, पुडुचेरी के लॉ मिनिस्टर श्री के. लक्ष्मी नारायण जी, मिजोरम के लॉ मिनिस्टर श्री टी.जे. ललुनतुंगा जी, कर्नाटका के लॉ मिनिस्टर श्री जे.सी. मधुस्वामी साहब, आसाम के लॉ मिनिस्टर श्री रंजीत कुमार दास साहब और अरुणाचल से पधारे श्री तुमके वगर साहब, और जिन्होंने शिरकत की है उत्तर प्रदेश, गुजरात, पंजाब, केरल, गोवा और उत्तराखंड के मनी मिनिस्टर्स जो हमारे बीच में रहे थे, इस समय वो नहीं हैं, और हमारे अधिकारी श्री आर.एस. वर्मा साहब, राजीव मनी साहब, अंजू राठी जी, श्री राजेंद्र कश्यप जी, श्री राघवेंद्र जी, श्री पी पांडे साहब, श्री साजी कुमार साहब, श्री उदय कुमार जी, श्रीमती वीना कोटवाले जी, नीरज गयागी जी, राज्य के और केंद्र सरकार के हमारे सभी अधिकारी एवं कर्मचारी, देवी एवं सज्जनों, मेरा सौभाग्य है कि एक बहुत महत्वपूर्ण कॉन्फ्रेंस जो हमारे विधि एवं न्याय मंत्री श्री किरण रिजिजू जी की अध्यक्षता में 3 दिवसीय यहाँ संपन्न हुई है, इस महत्वपूर्ण बैठक के समापन पर मुझे आपका धन्यवाद करने का अवसर प्राप्त हुआ है। सबसे पहले मैं दुनिया के लोकप्रिय नेता और भारत के प्रधानमंत्री श्री नरेंद्र मोदी जी का आभार प्रकट करना चाहूँगा कि अपने व्यस्ततम समय में से समय निकालकर कल उन्होंने वर्चुअल हमें मार्गदर्शित किया। उनके सार्वजनिक और राजनीतिक जीवन के जो अनुभव थे, जो हमारे काम आ सकते हैं, उससे हमको परिचित कराया और हमारा मार्गदर्शन किया। चुनावी वर्ष होने के बावजूद गुजरात के मुख्यमंत्री पटेल साहब ने हम लोगों का स्वागत भी किया और अपने सुझाव और आशीष वचन हम लोगों को दिए। मैं सम्मेलन की शोभा बढ़ाने के लिए अपने सभी माननीय मंत्रियों का जो विभिन्न राज्यों और केंद्र शासित प्रदेश से आए हैं, उनका धन्यवाद देना चाहूँगा और उनके उपयोगी लाभदायक विचार हम लोगों को जानने का अवसर प्राप्त हुआ। मैं केंद्रीय विधि एवं न्याय सचिव एवं लीगल अफेयर्स उनका धन्यवाद देना चाहूँगा। मैं श्री सचिन सिंधे जी का धन्यवाद देना चाहूँगा, जिन्होंने इस सम्मेलन की प्रत्येक गतिविधि का व्यक्तिगत रूप से पर्यवेक्षण किया और आयोजन को सफल बनाने के लिए समृद्ध बहुमूल्य विचार प्रस्तुत किया। मैं उन सभी प्रतिष्ठित राज्य और केंद्र शासित प्रदेशों के सेक्रेटरीज जिनकी उत्कृष्ट प्रस्तुतियों देने और इस सम्मेलन को सार्थक और मूल्यवान विचार देने के लिए जो आज के सेशन हुए हैं, उसमें मेरे सेशन में भी 14 राज्यों के सेक्रेटरीज थे, जिन्होंने अपने लंबे दीर्घकालीन जीवन के विधिक अनुभवों से, केंद्र सरकार की योजनाओं से, उनकी अपनी राज्य सरकार की योजनाओं से और ख़ास तौर से उनके यहाँ जो एक उत्कृष्ट कार्य हो रहे हैं उससे उन्होंने अवगत कराया और एक कंपटीशन की भावना आपस में राज्यों में पैदा करने का प्रयास किया। इस सम्मेलन को सफल बनाने के लिए केंद्र सरकार और राज्य सरकार के, खासतौर से इस जिले के प्रशासन के सभी अधिकारियों का मैं धन्यवाद देना चाहूँगा। इस सम्मेलन के दौरान हमने विधि और न्याय मंत्रालय तथा सभी राज्यों और केंद्र शासित प्रदेशों के साथ कई सूचना प्रदायक सत्र किए थे। हमने स्टैच्यू ऑफ यूनिटी, जूलॉजिकल पार्क का दौरा किया। पिछले 2 दिनों में एक सांस्कृतिक कार्यक्रम भी किया, जिससे हम जो देश के कश्मीर से कन्याकुमारी और कच्छ से लेकर कामरूप तक विभिन्न राज्यों और केंद्र शासित प्रदेशों के मंत्री और अधिकारी यहाँ पर आए हैं। हमने गुजरात की सभ्यता, संस्कृति, आध्यात्म, लोक भाषा, लोक भोजन, लोक नृत्य, इसको महसूस किया है और एंजॉय किया है। मैं अपने कर्तव्यों में विफल हो जाऊंगा यदि मैं टेंट सिटी के अधिकारियों और साथ साथ सुचारू और निर्बाध आतिथ्य सुनिश्चित करने वाली एजेंसियों के प्रति अपना धन्यवाद नहीं दूंगा। मैं विधि न्याय मंत्रालय के प्रत्येक अधिकारी कर्मचारी को भी धन्यवाद देता हूं, जिन्होंने इस कार्यक्रम के आयोजन में कोई कसर नहीं छोड़ी और इस आयोजन के लिए कड़ी मेहनत की। मुझे उम्मीद है कि ये सम्मेलन हमारे देश के भविष्य के कानून सुधारों को एक बड़ा प्रोत्साहन प्रदान करेगा। एक बार फिर मैं सभी को सौहार्दपूर्ण सहयोग के लिए धन्यवाद देता हूँ। किरण रिजिजू साहब का धन्यवाद इसलिए देना चाहूँगा विशेष तौर से कि स्थान का चयन उन्होंने बहुत उत्तम किया है और वो स्वयं भी तीनों दिन पूरे समय उनकी गरिमा में उपस्थिति हम लोगों के बीच में रही और हमारी ऊर्जा को बढ़ाने में काम किया। जगह का चयन का ये प्रभाव पड़ा है कि भारत की एकता, भारत की अखंडता, भारत का भाईचारा और ख़ास तौर से सरदार पटेल की नम्रता में दृढ़ता और उनके कठोर किंतु दूरदर्शी लाभदायक निर्णय की भावनाओं से हम लोग अवगत हुए। मैं आपकी सुखद यात्रा की कामना करता हूं और इस शेर के साथ अपनी बात समाप्त करता हूं कि सितारों को महफूज कर लो आंखों में, बहुत दूर तक रात ही रात होगी। मुसाफिर हैं हम भी, मुसाफिर हो तुम भी, फिर किसी मोड़ पर मुलाकात होगी। धन्यवाद।
आपका बहुत बहुत धन्यवाद सर। With this we had reached the conclusion of the conference and with the permission of the Honorable Chair, I declare this conference closed. Thank you, all of you. Everybody is invited to kindly join us for the lunch. Thank you. Before that, I had an important announcement. We have the officials of Statue of Unity. तो कुछ ऑफिशियल फॉर्मेलिटीज़ रह गई हैं. मेरा सभी मंत्री गणों से अनुरोध है कि वो उनकी नोटबुक में अपने एक्सपीरियंसेस शेयर करें. द ऑफिशियल्स ऑफ द स्टैच्यू ऑफ यूनिटी may please come and take the experiences of the Honorable Law Ministers present here. Thank you.